May it please, Your Lordship. Lordship, I beg to mention for listing of two repetitions for tomorrow, my lord, pending repetitions, my lord, for the admission, my lord.
Tomorrow?
Tomorrow, my lord.
It's already pending.
Pending, my lord. Pleadings are completed, my lord, and it is ready for disposal, my lord. There is an urgency because my tender was financed.
For DB?
No, it's just a single bench matter, my lord.
No, tomorrow is DB there.
If after the DB, my
The
lord,
day after tomorrow. Oh.
day after tomorrow,
Friday or Monday?
then my lord may fix it on 20th, my lord.
Okay.
20th of May, my lord.
Okay. Mm.
Obliged.
May I
28th is?
Wednesday?
20th.
20.
It's Wednesday.
Wednesday. Okay.
My lord.
May I, Your Lordship? I beg to mention item number 26, Your Lordship. This matter to be listed after 2 weeks. I have taken concern, Your Lordship.
26. Okay. Ms. Pango, Lana Government Advocate for the state respondent, with the consent of the Lana Council for the petitioner. When do you want to say?
After 2 weeks, Your Lordship.
Praise for listing this matter after 2 weeks. The prayer is allowed. List this matter after 2 weeks.
Obliged, Your Lordship.
You are also present?
Yes.
Okay.
Let it be a fixed date, my lord, maybe given, my lord.
When?
Second. Oh, 2nd of May, my lord.
That 2nd of?
May, my lord.
That may not be
Oh,
possible.
sorry.
2027 will be
My
possible.
lord, I'm sorry, my lord. 2nd of June.
June.
2nd of June, my lord.
June. 2nd June is no, it's a DB day. Tuesday. 3rd. 3rd June.
4th.
3rd June.
3rd June.
Okay.
4th June, Your Lordship. 4th is DB.
4th is again DB day.
Then 5, Your Lordship.
Friday.
Okay. Okay.
Obliged, Your Lordship.
May, Lordship,
Hmm.
I would like to mention item number 22, Lordship. Lordship, on instructions of petitioner, Lordships, he does not want to continue this matter furthermore, Lordship. So, Lordship, please to allow to withdraw this matter, Lordship.
Item number?
Item number 22.
Okay. Mr. G.
Ji Bam, Lordship.
Land Council for the petitioner submits that he has an instruction that the petitioner does not want to pursue with the matter. Accordingly, he does not want to pursue with the matter, and prays for allowing him to withdraw the same. The prayer is allowed. This writ petition stands dismissed on withdrawal.
Yes,
Okay.
sir. Much obliged.
May I, Your Lordship? Your Lordship, I beg to mention item number 7, Your Lordship.
Item
7.
yes.
Here, Your Lordship, we need some more time to seek instructions, Your Lordship. May we be granted 3 weeks time, Your
You
Lordship?
have informed the
Yes, Your Lordship.
okay, Mr. Ram, Lana Government Advocate, appearing on behalf of the state respondent, submitted. He need some more time to obtain instruction. Therefore, prays for adjournment of the matter for
After 3 weeks, Your Lordship.
3 weeks. He has also obtained consent from the Lana Council for the petitioner. In view of the above, and as prayed for, come and list this matter after 3 weeks. Okay.
Obliged.
May I please, Your Lordship? I beg to mention an unlisted eviction matter, my lord. For today,
Today,
my lord.
unlisted
Unlisted writ petition, eviction matter, it's urgent.
eviction matter.
Yes, my lord.
Tomorrow is DB day. Day after tomorrow? Tomorrow, today, okay, if permitted.
Yes, my lord. It may be taken as a last matter, my lord.
Okay.
Yes.
Yes, please, Lordship. I beg to mention item number 20, Lordship. Service upon respondent number 3 is still awaited, Lordship.
20.
20.
You are for the petitioner.
Yes, Lordship.
Miss
P. Rabha.
Lana.
Lord, I'm there for respondent number 2 in item number 20.
Okay. Service awaited
For respondent number 3, Lordship.
3. Okay. So whether respondent number 2 has filed affidavit?
Yes, my
No,
lord, we have
Lordship.
filed. We have filed, my lord. We have already filed.
Okay. And Mr.? You are Mr.?
T.
Your good
Marngar,
name, please. Lana Council for the respondent number 2. Stop. The record reveals that. Have you seen the record?
Yes, Lordship.
Okay, the notice upon the respondent number 3 is still awaited. In view of the above, let this matter be listed after.
In the month of July, can it be on month of July, first week,
Why
Lordship?
not? July,
June, Lordship,
June. When? Okay,
first week, Lordship.
first week of June. Okay, list the as prayed for, list the matter during first week of June. Okay.
My lord,
Lordship,
my
As,
present,
21 years
on the
old
date and
matter.
on the date to be fixed by the registry. Okay.
Also, item number 21, Lordship. In that, Lordship, 3 and 4, Lordship.
Okay, then here 3 and 4 is awaited.
4 and 5, Lordship.
4 and 5 is awaited.
Lordship.
Huh?
my
Otherwise,
lord, here on for 2 and 3, my lord.
okay, here Mr. Is appearing on behalf of 2 and 3. Okay.
Lordship, I would like to mention item number 24, Your Lordship. Here we have to file affidavit on behalf of respondent number 2, Your Lordship. 3 weeks may be granted to file affidavit, Your Lordship. I've taken the consent.
Okay. Ms. Basar, learned government advocate, appearing on behalf of the state respondent. Number 2, prays for further 3 weeks. Prays for and is granted further 3 weeks time to file affidavit in opposition. Stop. Okay.
Obliged.
My lord, I'd like to seek some accommodation in item number 13, my lord. As the conducting council is unable to appear today due to some personal difficulties, my lord. Item number 13.
13.
Yes, my lord.
Okay. Mr.
Techitopu, my lord.
Techitopo, Land Council submits that the conducting council, Mr. JTK, is out of station. Therefore, pray for adjournment of the matter for
1 week, my lord. After 1 week.
a week. Okay, the prayer is allowed. List this matter after a week. Okay.
Grateful, man.
May I please, my lord? My lord, I beg to mention item number 18, my lord. My lord, here I am appearing for the respondent number 5
Okay,
to 20.
what we'll do is in the order, will not adjourn in the, not mention, will, because we need to see the record. We'll give adjournment,
My lord.
wait for some time.
Yes, my lord.
Okay, otherwise everything will be disposed of in the
Okay, my lord. Deeply.
mentioning, at the mentioning stage. Yes,
Your Lordship, I beg to mention item number 14 and 15. I'm appearing behalf of V. Jammu. Currently, council is out of station. So kindly this matter may be fixed for 25 May.
Jammu is out of station.
Yes, Your Lordship.
Okay. Is there any private respondent here?
Your Lordship, we have taken consent from other parties.
Okay. Mr.
C. Tajo.
Tajo Lana Council submits that the conducting council, Mr. Jammu, V. Jammu is out of station. Therefore, prays for listing this matter on 25
May, Your Lordship.
May. He has also obtained consent and a consent from the council for the other side. Okay, as prayed for list this matter on 25 May. Okay.
Your Lordship, also item number 27. I'm appearing behalf of Deep Pangi. Due to some personal difficulties, he is not able to come. So kindly this matter may be fixed on 20 May, Your Lordship.
Okay, Mr. Tajo. Lana Council submits that the conducting council, Mr. Dicky Panging, has some personal difficulties today. Have you informed the other side?
27.
Have you informed the other side?
Yes,
Province,
sir.
okay. Difficulties, and therefore pray for adjournment of the matter for
20 May, Your Lordship.
20 May.
20 is Wednesday, Lordship.
27,
21
I
is Thursday.
20,
It's Wednesday.
okay.
20.
No. 20 May.
21 May.
20 is a Wednesday.
Yes, 21.
Hmm?
You can fix it on 21st May.
Well, 21 is a Thursday.
Yes, Thursday we have, oh, sorry, yeah, it's a single.
20 May, the prayer is allowed. List it accordingly on 20 May. Okay.
21
21 is a Thursday. DV day.
Then 22.
22. Okay. 22. Okay.
My lord.
May I, Your Lordship?
Yeah.
Your Lordship, I beg to mention item number 8. Kindly, this matter may be adjourned for today and then fixed on 2/6/2026.
Anything survive in this case?
Your Lordship, there's an interim in this case. This is a transfer posting matter.
Okay.
Your. Okay, we have.
But
five,
then
Your
the
Lordship.
respondent, it appears that respondent.
I have taken the concern, Your Lordship.
Okay.
Concern is already
What
taken.
I'm asking is the respondent probably is already been transferred somewhere.
Yes, Your Lordship. Therefore, Your Lordship, there's one more case, Your Lordship, with regards to the same party, Your Lordship.
Okay.
So there was a subsequent development over there. That is listed as item number 23, Your Lordship. But in that case, Your Lordship, that service is still awaited, Your Lordship.
Okay. So you want this matter adjournment for?
1823, no?
On 2/6/2026.
2/6.
2/6.
Mr. Jambasiri, Land Council for the petitioner, prays for listing this matter on you have informed
Yes, Your Lordship.
the council that it will be fixed on 2/6.
2/6/2026.
Okay, with the consent of the Land Council for the respondent, prays for listing this matter on 2/6. The prayer is allowed. List this matter accordingly on 2/6. Okay.
Your Lordship, there's an interim that may be continued.
The interim order passed earlier shall continue till then. Okay.
23?
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 28, Your Lordship, with the consent from the state respondent. Your Lordship.
Item
28. Your Lordship. Finally, this matter may be listed after 2 weeks.
Okay, Mr. Ibram, Land Council for the petitioner with the consent of the Land Council for the other side, prays for listing this matter
After 2 weeks.
after 2 weeks. The prayer is allowed to list this matter after 2 weeks.
Much obliged.
Okay.
May I please, my lord?
Yeah.
My lord, I beg to mention item number 16 on the request of CGC, Mr. K. Lawyer. Matter may be posted after 2 weeks or on Monday, this coming Monday.
Okay, as prayed for by Mr. H.K. Jamo on behalf of Mr. T. Party. You are on behalf of the
16.
petitioner.
Yes, on the request of the CGC is the respondent, Mr. K. Lawyer,
Okay, because Mr.
to be posted on Monday, this coming Monday.
Yeah. K. Lawyer is
K. Lawyer, CGC.
CGC, Land Council for the respondent with the consent
K.
of
Lawyer.
the Land Council for the
16.
petitioner. Pray for listing this matter on
This coming Monday.
Monday. Okay. The prayer is allowed. List it accordingly on Monday. Okay. Write the date. Huh?
My lord, the another matter I beg to mention is item number 29. I've taken consent from the learned DSGI M. Kato. I'm for the private respondent. Item number 20, the last item.
You are for the private respondent.
Yes, there are 2 private respondents. My lord.
Okay.
This is an arbitration appeal. My lord, can this be posted on 26 May? The councils are coming, leading council is coming from Guwahati.
Okay. Mr. Jamo, Land Council for the respondent number 2 and 3.
Yes, 1 and 2, my lord.
1 and 2. Praise for listing this matter. The submits that the leading counsel in this case for the respondent would be coming from Guwahati and therefore pray for listing this matter on
26th of May.
To which Mr. M. Kato, Land Council for the appellant has no objection. Prayer allowed. List it accordingly on 26.
Highly obliged, my lord.
Okay.
May I please, Your Lordship, I beg to mention item number 17, Your Lordship. I have informed the other side.
Will grant you. Will grant you. Wait for some time. It's order. Okay.
All right, Lordship.
Item number 1.
This contempt petition is against 7 contemners for willful disobedience of three consecutive orders of this honorable court. 19/2/2026, 12/3/2026, 26/3/2026, which was passed in three writ petitions, 63 of 2026, 97 of 2026, 118 of 2026. In fact, these three matters, they are connected matters. Subsequent orders were passed by this honorable court. Now, in that, the operating portion of the orders, page 22 is the first order passed by this honorable court. Last paragraph. Considering the submissions of the learned counsel for the petitioners and prima facie the constitution of Arunachal Cricket Association in respect of preparation of electoral roll as well as the appointment of electoral officer appears to have not been followed. It is hereby provided that the AGM election of the Arunachal Cricket Association proposed to be conducted on 24/2/20 shall be subject to the outcome of this writ petition. And if the AGM is conducted, same be conducted in accordance with law.
So which has been violated?
This order also has been violated, Lordship. And
Not-
subsequently,
not-
after passing of this
The
order,
in accordance with law? Which one?
yes, same be conducted in accordance with law. Subsequently,
According to you, it was
when
not
it was violated, Lordship,
Huh.
when it was violated, we have filed one separate writ petition challenging
no.
the violation of that
So you mean to say that it was not, election was conducted?
in
and-
violation of
It was not conducted in accordance with law?
bylaws of the Arunachal Cricket Association. Now, in this order, the court has categorically directed them to go as per the bylaws. AGM same be conducted in accordance with law. That means as per the bylaws. Now, since the election was not conducted as per the bylaws, subsequent WPC was filed,
Mhm.
page 23. WPC number 97 of 2026.
Page?
23, Annexure 2, page
Okay.
23. This WPC number 97 of 2026 was filed.
No, when this was
The
not,
AGM was conducted,
okay,
the election was conducted, but that election was not as per the bylaws of the Arunachal Cricket Association. That is, that very election was conducted in violation of this order. Lordship. So this writ petition was filed, challenging
by
that,
by the
that
same
result,
party,
result notification
by the same party?
by the same party. By the same party.
Okay,
Now,
impleading the same respondent?
same respondent.
Okay,
Then by this order, 12/3/2026, the result was stated. Lordship will find the relevant portion of the order at page 28. Having regard to the projection made, it prima facie appears that the relevant provisions in the constitution of the association and the rules and regulations have not been adhered to, and therefore the impugned declaration of result dated 24/2/2026 is state till returnable date.
no, keep there. Still returnable date.
That result was accordingly stated in this writ petition number 97 of 2026.
Declaration
Yes.
state.
State was stated.
Subsequently, it was-
Accordingly, page number 30, Lordship, Annexure 3, page number 30, the order of this honorable court was communicated to all the respondents, which was duly acknowledged by them, Lordship. Lordship will find at page 30, in the middle of the this paper, Lordship will see that they have received a receipt on behalf of respondent number 1 to 8 and 10.
Okay.
They have received. And page number 34, Lordship. In their subsequent orders also, they clearly talks about the stay of that particular result notification in this opus memorandum. Consequent upon the verdict of WPC number 97 of 26, wherein the Honorable Guwahati High Court, Itanagar Parmanjit, has stated the election result of Arunachal Cricket Association, which was held on so and so, the office bearer of Arca as on 200 is deemed to have been resumed the duties and responsibilities of Arca. This will continue till the stay is vacated or the stay writ petition is disposed of by the Honorable High Court. Now, by this order, they are acknowledging that there is a stay from this Honorable Court. But in spite of acknowledging that there is a stay of this Honorable Court, they keep on functioning, Lordship. Subsequent page, Lordship, page 35, they came up with another notification. They were still functioning, Lordship. In spite of stay from this Honorable Court, and then subsequent page number 36, 37, they keep on functioning.
Just a
Lordship.
minute, by this order, the office bearer. Okay, deemed to have been resumed. Election was conducted or not?
Election conducted, Lordship. A result was also declared, Lordship.
No,
that
when?
was state.
No, this order was passed on 12/3. Declaration of result dated
24 to 2026, Lordship. That was the date
Okay,
when the
result
election result was
declared.
declared.
But is this the person who were elected?
Yes, they were the person who were elected, Lordship.
The person who is
The contemner in this case.
no, who is the who's the office bearer of so and so deemed to have resumed the duties. So these elected persons were allowed to resume the duty.
No, Lordship. They were. This officer memorandum was also put to challenge in subsequent writ petition, Lordship. That was also a state, Lordship.
No, who resumed the duties?
No, so why, Lordship? Why? How can they resume, Lordship? Before declaration of result, how can they resume the
No,
office?
that is why I'm asking.
Lordship, that is
Whether
the
are these person who resumed the duties are the same person who have been in the election?
Lordship. Election
Declared
result was declared on 24th February 2026. Now, by this office memorandum, they are trying to say that they resumed the office before declaration of the result. How is that possible, Lordship? So why this office memorandum was also put to challenge in the subsequent writ petition, Lordship. Another writ petition was filed, Lordship. That is writ petition number that I have annexed, Lordship. Page 50, Lordship, annexure 14.
Okay.
That all subsequent development that took place, Lordship, in violation of that stay order, Lordship, that was again put to challenge in this writ petition, Lordship. Again, by order dated 26/3/2026, Lordship. All those notifications, show cause notice, office memorandum was state, Lordship. Lordship will find that that particular operating portion at page 62, Lordship, paragraph 6, Lordship, is the operating. It appears that WPC number 97, by order dated 12/3/2026, a coordinate bench of this court has stayed the declaration of result dated 24/2/2026 till returnable date, fixing the matter on 6/4/2026. However, in the total disregard to the direction issued in the order dated 12/3/2026, respondent have deemed to have assumed the duties and responsibilities on 23/2/2026, and also issued notification on 13/3/2026, circular dated 17/3/2026, the show cause notice dated 17/3/2026. Thus, a prima facie case is demonstrated by the petitioner in their favor, and accordingly, they impugn office memorandum dated 13/3/2026, their notification dated 13/3/2026, show cause notice dated so and so, and circular dated stay till returnable date, Lordship. Now, accordingly, all those subsequent development that took place, Lordship, after a stay of the election result, those were also stayed by this writ petition, Lordship. Now, Lordship, this order was again communicated to all the alleged contemners. Page number 64, Lordship. Lordship will see in the down below, Lordship, they have received. It was acknowledged by them, Lordship. Serial number 1 to 8 and 10 again, same, Lordship.
Now, in spite of receiving those stay order from this honorable court, Lordship, they keep on functioning, Lordship. Page number 69, Lordship. Page number 70. And recently, Lordship, in page number 71 and 72,
The person who-
73,
who-
yes.
Who issued this order at page 69 is the respondent.
Yes, Lordship.
Okay.
And then, Lordship will see, recently there was a inauguration of indoor cricket stadium, Lordship. There, Lordship will see at page 72, Lordship.
Okay. Their names are there.
Their names are there, Lordship. So by this contempt, Lordship. So at this stage, Lordship, notice may be issued, Lordship.
Okay. Heard Mr. J. Gini, Land Council for the petitioner. This is an application filed under section 11 and 12 of the Contempt of Court Act 1971 for willful violation and non-compliance of the order dated 19/2/2026. Passed in WPC 63/2026, comma, order dated 12/3/2026, passed in WPC 97/2026, and order dated 26/3/2026, passed in WPC 118/2026. All analogous matter. Okay. Stop issue notice. Returnable by, we'll say 4 weeks. Okay, stop. The petitioner shall take steps for service of notice upon the respondents by a speed post as well as by usual process within a week from today. Stop. This is matter after 4 weeks. Okay.
Item number 2 to 4.
It's the same matter, Lordship. This matter has been listed
Mhm.
In item number 4, Lordship, WPC number 118/2026, Lordship. Since all those rest of the two was merged with this, since it is an analogous matter, Lordship, the last order, Lordship, which I have read it out, Lordship,
Mhm.
there was no direction to take steps from this honorable court, Lordship.
No notice was issued.
No, notice was issued, but yes, Lordship, no direction as such to take steps, Lordship. So,
No notice was issued.
item number 2, Lordship, in item number 2.
Item?
Item number 2.
2.
Yes, WPC number 118, Lordship.
Notice was not issued.
Notice was.
Hard, Mr. Who else? Whether the states are also being implemented as respondent?
No, Lordship.
In item number 3, we are for respondent number 6.
118, we have not made them as a
Okay.
party. Lordship. Yes, in item number 3, they have been made as party.
Okay,
They are already,
then this will be in item number,
since it's an analogous matter, Lordship,
hmm,
item number 3 and 4 is connected matter.
okay, 118 is item number 2,
Yes.
in item number 2. Okay, analogous. Okay, heard Mr. J. Gini, Land Council for the petitioner. Stop, huh? Okay, notice was not issued, okay. It is submitted that this court by an order dated 26/3/2026 had granted there is interim.
Yes, Lordship.
An interim order by staying the impugn action of the respondents. Stop. The relevant paragraph of the order dated 26/3/2026. No, it's 2026 is reproduced below. Para 6, huh? It appears that, huh? Okay. Para 6, stop, huh? However, no notice was issued at that stage. Stop. Accordingly, let a notice be issued. Accordingly, issue notice to the respondents. Returnable by, we'll say.
Lordship, I may be allowed to take dusty service, Lordship. In the previous time also, Lordship, we have
Okay.
taken dusty service.
Issue notice, okay, stop, huh? Since, sorry, the petitioner prays for allowing him. The petitioner submits that since the notice has already been issued in analogous matter, he may be allowed to take steps upon the respondents by dusty service. The prayer is allowed. Stop. Notice upon the respondents by way of dusty service within a week from today. Stop, huh? And file affidavit, compliance affidavit to that effect. Stop. List these matters after 3 weeks.
3 weeks, Lordship.
Okay.
Obliged.
Item number 5.
Yes.
May I
What
please,
is this?
Your Honor?
What is this? It's a fixed matter.
Lordship, I have challenged the impugn order dated 9/3/2026 passed by the respondent number 3. That is the Deputy Commissioner, Capital Complex, page number 29, annexure 8 of my writ petition, Lordship.
Okay.
Lordship, may I read the order? Whereas the government of Arunachal Pradesh by order number so and so 6 March 2026
has reviewed the operation of weekly market in the state and designated Saturday as the only day for conducting weekly market in Itanagar capital region. Therefore, in pursuance of the above government order, all the weekly market owners in Itanagar capital region are hereby directed to conduct their market once in a week, that is on Saturday. All the standard operation for operation of weekly market as per earlier order dated number so and so, dated 22nd July 2025, shall remain the same. The SP of Itanagar, Nahalagan, and administrative officer of so and so.
So,
Lordship, the basic contention of this order is that the DC has promulgated an order to the effect that the weekly market will be conducted only on Saturday in a week.
based on the decision of the government.
Yes, yes, based on the decision of the government. Now, Lordship, the present writ petition before this honorable court is a honor of the weekly market. Lordship may come to the page number 17 of my writ petition. Lordship, the petitioner is the proprietor of a trading license in the name and style of MS Kinam Business Global Hub. It is a trading license issued by the same competent authority, that is respondent number 3, the Deputy Commissioner Capital Complex, for running various trades such as general trade, grocery, agriculture and horticulture item, vegetables and fruit, retail in ready-made garments, cold drink retails, shoe centers, fish, meat, etc.
On which date? Which day?
Every day, Lordship.
Every day?
Yes, every day. So, Lordship, based on this trading license, I am running my business at designated place, that is at Lekki village near ISBT, Lordship. Every day.
This is a normal trading license being issued to the business.
Yes, Lordship,
Okay.
but it has, Lordship, under my trading license, Lordship, there are around 128 vendors. I have given in my writ petition, page number 20 and 21. These are the list of vendors.
No, that is true, but then it's every day.
Yes, Lordship.
Every day.
Every day I am running my business, but more particularly on Friday, Lordship. On Friday, I am running weekly market.
Now, this is only weekly. This talk about the weekly market only.
Yes,
The
Lordship.
order is restraining weekly market to operate only on one day, on Saturday.
Yes,
Not on any other day.
Yes, yes.
So yours is also that kind of a weekly market.
Yes, but I am running on the basis of this trading license. I am running every day, but I am running weekly market.
This notification will not affect you.
Lordship, I am running
If it is the normal trading license. to
Lordship.
run the-
Lordship, may come to page number 24. May I please, Lordship?
Yes.
Page number 24 is a money receipt, Lordship. Received a sum of rupees 50,000 from Sri so-and-so, owner of Friday Market, Lekki, as per order dated number so-and-so, being the security amount for performance of standard operation procedure dated 18/9/2025. Lordship, out of this trading license, I am running my business every day, but Lordship, I am doing weekly market only once in a week, that is Friday, Lordship. I am running weekly market Friday, which is also recognized by the district administration and deputy commissioner, that is respondent number 3. Now, Lordship, this impugn.
Now, what is the difference between this trading license and the license to run the weekly market.
Lordship.
Hmm.
I am having my business establishment there during normal days, only designated shops are only being operated. But on Friday, Lordship, vendors from nearby area, including Assam, they come, Lordship, during only on Friday, they come. Now they come and they run their business. And the government has also, Lordship, given me direction to maintain the standard operation procedure as because the government is of the opinion that because of conduct of this weekly market, the outsider immigrants, they are coming to the Itanagar capital complex. As such, they have formulated an SOP and they has directed me to abide by all the terms and condition of the SOP. And I, being a bona fide businessman, Lordship, I am complying all the SOPs, and I have also given an undertaking which
Now, this license
Lordship,
is for one shop or more than one shop?
it's a complex of shop, cluster of shop. Normally also,
Normally, what we understand is
Lordship.
every shop has their own license.
Lordship.
This is for multi-shop. Huh?
Yeah, this is like,
Where it is?
it is near ISBT.
No, where it is? Where do we find that this is for multi-shop?
Lordship, in the very
For multiple
trading license, page number 17, Lordship.
17,
Yes, page number 17.
grocery.
Yes, grocery is there, vegetables and fruits are there. Retail of ready-made garments. These are the items which are covered in weekly market, Lordship. In the weekly market also, Lordship. Grocery.
Then that means this way, entire Nahalagan market can have only one trading license.
Lordship, out of this trading license, but I am not doing weekly market every day, only on Friday.
This notification talk only about the weekly market only.
Yes, weekly.
Probably not connected with this.
No, Lordship, it's connected, Lordship. Lordship, may kindly see that.
Where do we have seen in other that for operating weekly market, there is a separate trading license.
Yes,
to
Lord.
run weekly market on Friday, Saturday.
Lordship, that is there. I agree with that. I agree.
In your case, where is the license?
This is the
Allows
license.
you to run the weekly market.
Lordship,
Weekly market is something different where everyone comes from the outsider also. And that is because of that, the
Lordship, this
authority probably found difficulties in administration also.
Lordship, may come to page number 26, Lordship again.
26.
Yes, Lordship.
Yes.
This is an affidavit come undertaking directed by the respondent number 3, that is Deputy Commissioner Itanagar.
Okay, this is
Lordship, married.
yes.
I, Sri Teli Rotu Kamdir, owner of weekly market, that is Kinam Business Global Hub, that is the same trading license. Friday market, Lekki, Lordship, it is clearly written, Friday market.
This is your undertaking.
Yes, yes.
Where is the authorization? Where is the order authorizing you to run this early market?
Lordship.
You can declare that another declaration also that saying that starts Thursday market, Monday market.
No.
And where is the order
Lordship,
passed by the Deputy Commissioner allowing you to run weekly market?
Lordship, this trading license is sufficient, Lordship.
Which one?
This trading license, which I've annexed in, yes, 17, annexed you.
It doesn't speak about weekly market.
Lordship, this doesn't speak about weekly market, but the items, trade items, Lordship. Trade items.
Like you have a complex. It looks like you have a complex. A
Yes.
business complex.
Yes.
Where this
I run,
horticulture, all those cold drink, shoe center.
yes.
that-
Normal day that exists, Lordship, in normal day, in 6 days of a week, it do exist.
Mhm.
But Lordship, on designated day, that is,
Where is the order for allowing you to run weekly market? on a
Lordship,
designated day?
Lordship, page number 24.
24.
This is not not the authority.
Receive.
But Lordship, they have, it is their document, Lordship. I have annexed, but it is their document, Lordship. Rupees 50,000 has also been taken, and I have been running. It's not the case that I am not
This appears that you were allowed to
Run
operate a weekly market.
in a
For that you have paid and this is a receipt. Where is that order allowing you to run the weekly market?
there is no order, Lordship. There is no order.
Then where, then on what basis you are running weekly market?
Lordship, the authority has allowed me. Lordship, the authority has
Where
allowed.
is that order?
Lordship, first of all, Lordship, I am having a valid trading
Yes,
license.
That order is at page 22, Lordship.
22 order. Why you are hiding? Huh? Weekly market permission is granted, hereby granted to, see this is permission. You did not see this.
No, Lordship,
I
this
was
is,
asking for this all around. Also.
so Lordship, I have been,
Yes, yes. It
yes,
says that it's on which day? Friday.
yes, Lordship, it's a designated day. Now, Lordship,
You
that,
have a valid
yes, Lord.
permission.
Now the
Okay.
question is that, Lordship, by this impugn order, how I am aggrieved, Lordship? Lordship, on Saturday, they have designated the,
Saturday only.
yes, they have designated,
There was some order passed in the
yes, Lord.
analogous matter.
Lordship, now the same impugn order, Lordship, I have mentioned.
Facts are a little different, Lordship.
Okay.
Facts are different.
You have a interim prayer also.
Yes, Lordship, and Lordship,
Now, after this notification issued by Deputy Commissioner, whether you are running.
no, I am not running.
Stop.
Being a law-abiding citizen, I have to stop.
What is the difference?
But Lordship, may I submit two more lines, Lordship? Lordship, same impugn order dated 9 March 2026 has been already stayed. In another writ petition, the Lordship, I have annexed in writ petition number 324. This impugn order has been stayed, and writ petition number 101/2026. These writ petitioners and Lordship, the present writ petitioners, they are standing on the same footing, Lordship. So as such, Lordship, I pray that this impugn order may be stayed. And moreover, Lordship, the present order, impugn order, has been passed in violation of principle of natural justice. No opportunity of hearing has been granted to me, Lordship. It has been issued arbitrarily, Lordship. As such, I pray that since it is a question of poor 128 vendors, businesses in stake, it may be stayed,
Yes,
Lordship.
what is the difference, Mr.? Yes, Tapin. What is the difference between the other and the present one?
Here, Lordship, before coming to that judgment, Lordship, yes, I'd like to take Lordship to the order of the state government. It's page 28, Lordship. Lordship, so far, the administrations of law and order, Lordship, and management of traffic management, all are purely administrative, Lordship, issue, Lordship.
Right.
Where, Lordship, this honorable court will have a little say on that, Lordship.
Right.
Here, the government has taken a decision. They're looking to Lordship, law and order and some traffic issue, that only a particular date may be given. This is a Saturday, which is convenient for all the Lordship the people, including the administration, Lordship. And Lordship, kindly come to page 27 first, Lordship. Looking to the law and order and traffic congestion, Lordship. There was a meeting in the government level, Lordship, after decisions under the chairmanship of Commissioner Home. And they sought, Lordship, the opinion from all the deputy commissioner. Not all the deputy commissioner, all the concerned. Lastly, say, after due deliberation, it was unanimously decided to formally seek comments about the aforesaid feasibility from the DCs within a week time, and thereafter the Home Department will examine the same and submit the report for government decision, lawsuit. Thereafter, lawsuit next page, that's 28. Accordingly, lawsuit opinion was sought and it was discussed in the government level. Looking to the inter-lawsuit issues and factors, lawsuit, this decision has been taken that this the market may be held, but on particular day, lawsuit. Then lawsuit, the impugn order is page 29, lawsuit.
Yes.
Page 29, lawsuit. Here, what happened, lawsuit? Only the day has been changed. Weekly market means once in a week, lawsuit. That's a very lawsuit normal understanding. Once in a day, here lawsuit he was running on a particular day, that is a Friday lawsuit.
Now,
Yes.
can we
Now
change
it has been changed to the Saturday,
Saturday?
lawsuit.
So what is the difference?
How the petition is prejudiced, lawsuit? Not at all, lawsuit. And so for the other cases are concerned, kindly come to the Tana Height case, lawsuit, page 65. Yeah, na? Yeah, okay. Huh? Yeah, na? Pending it. Examine. Lawsuit, kindly come to page 30, lawsuit. Tana Height, lawsuit. 3030, lawsuit. This is judgment in Dolpish number 234/2025, which my learned friend is relying on, lawsuit.
Okay.
The facts is little different, lawsuit. Kindly come to paragraph 7, that's 8 page 32. What happened in this case, lawsuit? Page 32, it's paragraph 7, lawsuit. It appears that the impugn order dated so and so is passed on the basis of minutes of meeting held on 30/4/2025 under the chairmanship of Home Minister, Government of Arunachal Pradesh, to review the implementation inner-line permit system in the state. It also appears from the impugn order dated so and so that before suspending all the weekly market operating within the jurisdiction of Papumari district and cancelling all the permits license to individual also and so vendor for conduct so and so market within the Papumari district, the president was not given any notice so and so. Here, lawsuit, their permit itself was cancelled, lawsuit. And that permit was cancelled without lawsuit giving opportunity. It is categorical contention of petition that the appointment impugn order, the right to livelihood as granted under article so and so is violated. The submission so advanced by the so and so both parties need further consideration. At this stage, let notice be issued. Iska kya hua last judgment? Pending. Or this is pending. Here in this case, lawsuit, the holding of the market also is suspended, lawsuit. At the same time, lawsuit, this trading license is itself, it was lawsuit cancelled, lawsuit.
Without any notice.
Without, because if you cancel, suppose here in this present case also, if the Saturday Friday is cancelled without giving alternative day, lawsuit, then lawsuit opportunity has to be given, lawsuit, because that will prejudice the petitioner, lawsuit. But here the day only has been changed, lawsuit. And one more case which my friend is relying, that's that is page lawsuit 71.
WPC 10.
WPC number 101 of 2026 lawsuit.
It stands on same footing, Lord.
Here, lawsuit, the petitioner was given 2 days, lawsuit. In that case, lawsuit. In this particular page 71 lawsuit. In this particular case, WPC number 101 2026 lawsuit, license was given, a permit was given for holding twice in a week, lawsuit market. But one day was cancelled, lawsuit. One day was cancelled and one day was altered, lawsuit. Therefore, when you are cancelling, lawsuit, the permission itself, then you have to give opportunity. Under this circumstance, lawsuit, कौन सा Kindly, page 72, paragraph 3, Lordship.
Hmm.
Page 72, paragraph 3. Just we can gather from here, Lordship, difference, Lordship. Mr. Dekar, Learned Council for Petition, submitted the petitioner here was granted license to run weekly market twice in a week under the banner of so and Tuesday market so located at so and so within the jurisdiction so and so. But by imperial order so running of so was written to once in a week, Lordship. The case is different here, Lordship, because you can't cancel, Lordship. If you cancel, then Lordship, it will prejudice the petitioner, Lordship, without hearing that cannot be done, Lordship. This is the difference between these cases and the present case one, Lordship. This is purely administrative, Lordship, issue.
Okay. In your case, you say that you have a market complex. Normally it is running.
Yes.
It runs every day, but special on Saturday. Oh, sorry, Friday.
Weekly market has
Weekly
been
market is
designated.
Friday only.
Yes.
It can be changed to Saturday.
But Lordship, the problem is that if that is the case, there is no business. Honestly, I am apprising before this honorable court. If I run Friday market, sorry, a weekly market on Saturday, nobody comes. That is the main issue.
Saturday is holiday. Everybody can come.
No, Lord.
Friday, especially the government.
Because I have been running Friday market since long time. That's why the customers they have a mentality that the Friday market is.
Now they have a mentality that there is no market because you have stopped.
Lordship, as such, if
once you notify that the market has been changed from Friday to the scheduled market, Friday to Saturday, everybody will come again on Saturday.
My humble prayer would be that, Lordship, I have already given affidavit that I am complying the SOP formulated.
No, SOP will remain the same Friday or Saturday.
With strict terms and conditions, Lordship. On the basis of this SOP, I may be allowed to continue my Friday market on the same designated place.
We direct the authority that the notification, if required, on request being made by you, be changed for Saturday, from Friday to Saturday.
Lordship, that too without notification also, Lordship, on Friday, Saturday, I can run the market, Lordship. There is no impediment on running the market on Friday, Lordship. That is the case. Now also there is no impediment in running Saturday market.
Saturday
weekly market
profitable. Saturday would be more profitable, it appears.
No, Lordship. If there is that would have been the case, Lordship.
If there is no any other motive, then Saturday it appears
Lordship,
more profitable.
My prayer before this Lordship would be, I may be allowed to run weekly market once in a Friday.
No, what we'll do? We'll issue notice and let them file.
Yes.
And then let them propose that it can be converted or changed or what.
Lordship. In the meantime, the operation.
No, since you have already stopped, it will be difficult. It's not a case of cancelling. In your case, had it been the cancellation without notice, yes, of course. In the case of the others.
Lordship, they have already taken an undertaking. They have already taken money from me, that the municipal charges, etc., everything. I have already installed everything regarding the.
That will remain the same. That will remain the same. Only the day will change now.
If the day is changed, practically it becomes, Lordship, meaningless, Lordship.
Lordship, this permission was given on Lordship 12/9/2025, Lordship. Last year, Lordship. And since then, he has been running this business, Lordship.
Yes, I have.
And then, Lordship, this is only security amount, Lordship, deposited. It's not, Lordship, he has given to the state government. He will get it back, Lordship. This security amount.
But I have installed.
And since month of September 2025, he has been doing this business, private market, Lordship.
But
now only.
But then, Mr. Tapi, so even for this also, now you could have make a proposal that since you are running a weekly market on Friday, we are going to change it to Saturday. Notice could have been issued to him as well.
That part, Lordship.
making a proposal.
Because
So
we,
whosoever is running in other days, Wednesday, Thursday, Friday, whatever maybe, but then that used to be that we are going to change it.
That was also not
but
done.
definitely lordship here. The
Now,
peti-
immediately see, after this notification, they have stopped. You have informed the SP also.
Yes.
lordship, they
Straight away stopped.
no, stop in the sense lordship here. He has been given liberty to do this business on next day. That is Saturday lordship.
Where? No, no.
It's a,
By impune.
Okay.
it's a common
impune
impune.
order, it has been only day has been changed lordship.
That means.
We have not stopped lordship.
It came as a shock,
But
lordship.
cannot be
The impune-
inferred from that.
impune order, can you see the impune
Hmm.
order? What
Has it been mentioned that it because in the case yesterday I remember in the one same market, one person was granted to run weekly market on Friday.
Friday.
No, Wednesday or Friday.
Yes.
The other one was running on Saturday. So when it was proposed that why can't you run Saturday? Saturday is being given to somebody again. So in that case, it's difficult. So that is why you have to make a proposal. Notice has to be issued. And in the present case, you have supposing without license, supposing his license is only for Friday, unless it is changed, it will be difficult. You could have mentioned in the notification, whether in the notification has it been mentioned.
Not mentioned, lordship.
Let us see the notification that those who are running on other day may run on Friday, Saturday.
Page number 29,
29.
order, impune order.
Hmm. It's directed to conduct the market once in a week, that is on Saturday. So these also can be, of course, inferred from here.
Look, this weekly market, what they do, lordship? It's not the regular business, lordship. They comes out once in a week, lordship.
Yes.
Mhm.
They can comes out once in a week in Saturday also, Friday also, Monday also, Tuesday also, lordship.
There is,
And this honorable court, lordship, to my understanding, under 226 lordship, which day is feasible for the holding market, lordship. This court will not decide that.
Yeah, that
This is the lordship for the investigation to see
only if no notice or
how the
no
petitioner
opportunity
is
was given, then.
how the petitioner is prejudiced, lordship.
Mhm.
Suppose that every day he is running business lordship, then if I do this lordship,
no,
then
I am not running
definitely
market
the
every day.
petitioner is affected lordship. If he is not doing every day lordship, just I'm changing the day. You instead of coming tomorrow, you come day after tomorrow. That's the whole lordship.
lordship, I am not running weekly market every day. I am running weekly market only once in a day, that is on Friday, by the permission of the respondent number 3. That is the deputy commissioner. Now, without any notice,
No, Mr. Tab,
lordship,
see, page 29, para 2.
lordship.
Therefore, in persons of the above government order, all the weekly market owners in the Itanagar capital region are hereby directed to conduct their market once in a week, that is on Saturday. So whosoever is running in any other day,
All
it's understood
have
that
been
they have been directed to run on Saturday only.
But that has been stated in,
Now, we could have only, of course, that give me some chance, at least to notify the consumer that it has been changed to Saturday, give at least 1 week or 2 weeks, could have been made.
lordship may kindly read the order of
the
101,
department. Hmm?
WPC 101, that is page number 71, lordship. This rate petition stands in the same footing where the present rate petition is standing, lordship. Here, lordship para 4. On the other hand, so and so advocate submits that it is in the domain of the respondent authority to restrict the weekly market. However, she admits that the aforesaid order was passed without giving an opportunity of being heard to the petitioner. The submission of the learned counsel of both the parties need further consideration at
Okay,
this stage.
okay. So,
It has been stated, lordship, the proposal for running weekly market only on a
Mr.
designated
Tita,
day, that is,
Land Council for, yesterday also some order passed,
it,
similar to that I'll pass order.
it has
So
been
that
stated.
there, only the stay portion would be that you file affidavit and we are making a proposal that you have been offered. And then the notification clearly says that he has been allowed to run, he can run his weekly market on Saturday instead of Friday. And then there no prejudice has been caused. No? So that way it will go. But then in the meantime, since no opportunity was given, no chance to change the date also. So that actually you have also in other case say that no notice was issued. So that way timing. giving an opportunity.
In that case, Lordship,
Hmm.
in that case, what I just propose is that, Lordship, as I distinguish the present case from the other two cases,
Mhm.
Lordship, their license itself was cancelled, and in one case, two day was given, but one day was changed, cancelled, and only Saturday was given. So therefore,
Then what? Yes, please.
this is the Lordship difference between the present case and those cases, Lordship, and those cases are pending. And here, what I would like to propose is that in case if Lordship, this Honorable Court feel that Lordship opportunity should have been given, Lordship. So there's no point keeping it pending, Lordship. This matter may be allowed, directing the authority to take action, appraise, giving opportunity of hearing to the petitioner.
Mhm.
That can be happen in the other cases also, Lordship.
Yes, yes.
Ultimately, what can
Ultimately, this will be
that will happen.
consequences.
Yes. So there's no point keep it pending, Lordship, because it's saying what, Lordship. We authority we're facing the
We'll
difficulties.
give a week time so that they can also re-notify or reissue this notification saying that those who are running in other days are can run their market in Saturday only. That notification can be issued, but that is not clarified.
Lordship, may please kindly peruse page number 73 once. Ferrite. Lordship, actually, I have present 73. Ferrite. It appears that the impugn order dated restricting the weekly market to 1 day, that is Saturday, through the license, though the license was granted for 2 days, was passed without giving notice to the petitioner and without affording an opportunity of being heard. Thus, the principle of natural justice appeared to be violated. Accordingly, this case has been.
This is exactly, Lordship. From 1 day, it was restricted to 1 day.
1 day has been restricted to one.
The license was
although the license was for 2 days.
No.
Here he has
one case.
prejudiced. No notice was issued.
Yes.
So, but in your case, you have still Saturday. Here is a person who used to run market on Friday as well as
twice in a week.
Saturday. So his other day is cancelled. So that is why he came before this court and this protection. So in your case, you have alternate, no cancellation. Your only Friday can be changed to Saturday. There is a difference.
And the representation has been also given to the authority, but is still pending, Lordship.
Okay, pending.
Yes, Lordship.
Will direct the authority to dispose of your representation.
Till then, it may be kindly, Lordship. Is still.
See, now you're
Till then,
already stopped.
Till they file reply, Lordship. That is my limited prayer.
Lordship, what I'm praying is, Lordship, he is asking for a stay. I'm proposing it may be set aside, Lordship, giving opportunity to authority
till returnable date.
Proceed appraise, giving opportunity to the petitioner.
Okay. Mr. Itaba, Learning Council for the petitioner. Also had Mr. Chapi, Learned Senior Government Advocate for the state respondent. Staff and para.
Thank you.
By filing this writ petition under Article 226 of the Constitution of India, the petitioner challenged the order dated 9. No, this is not only for him.
Yes, this is common note.
Common.
This is common note.
So that is 9/3/2026 issued by the respondent number 3. Whereby respondent has restricted the weekly market to only once in a week that is on Saturday. Stop, sir. The grievance of the petitioner is that he has been issued where is the license?
Page
Seven-
17, Lordship.
17.
Trading license,
Yes.
page 17.
Annexure 1.
No, weekly market is
That is page 22.
Okay. Mm.
And so far, this trading license comes. This is a common trading license.
Mhm. He has been granted by an order that dated by an order dated 12/9/2025. He has been granted. He has been granted permission to run a weekly market at Lekki Village on Friday. Stop. However, by the impugn order, the by the said impugn order, the weekly market has been restricted only on Saturday. So it is submitted that before issuing of the aforesaid impugn order, no notice was issued to the petitioner, nor any opportunity of hearing was given to the petitioner. Stop. And thus it violated the constitutional right guaranteed to the petitioner under Article 21 of the Constitution. Stop. Mr. S. Tapping, Senior Government Advocate, submits, on the other hand, submits that by the impugn order passed by the respondent, only the date of the weekly market has been restricted to Saturday only, Saturday. And as the petitioner was granted to run a weekly market on Friday, no prejudice would be Friday. He has not been restricted to run weekly market on Saturday, and thereby no prejudice has been caused to the petitioner. However, he fairly submitted that before issuing the aforesaid notice, it appears no prior notice was issued to the petitioner. Staff, and since the petitioner is stated to have submitted a representation before the competent authority, that is Deputy Commissioner, to consider his case, this writ petition may be disposed of with the direction to the respondent authority, respondent authority to dispose of his representation, dispose of the representation submitted by the petitioner by giving him an adequate time.
Lordship, one small correction also.
Yes.
When Lordship is directing to dispose of the representation, if Lordship see come to page 74, Lordship, annexure 11, this is a so-called representation.
Okay.
But this is not submitted by the petitioner. This is submitted by one Gichik Tama at page 75, who is not the petitioner here, Lordship.
He is a general secretary, commonly I think for.
Commonly.
But you have not submitted a representation.
Therefore, Lordship, what I am just proposed, Lordship, instead of directing, because here the opportunity of hearing is not given as Lordship, observed, Lordship.
Okay.
It may be set aside and directing the authority to proceed appraise.
Okay. In view.
After hearing the petitioner.
Leave this representation part. Huh? So in view of the above submission of the Learned Council for the parties, it appears that, that from the above submission, it appears that before issuing the impugned order restricting the weekly market to one day, that is on Saturday, no opportunity was given to the petitioner of being heard. Thus, the principle of natural justice appears to have been violated in this case. In view of the above, the order dated 9/3/2026 is set aside, being issued in violation of the, set aside, However, so the DC should be given an opportunity.
With liberty to the competent authority
to
proceed appraise.
However, the competent authority, more particularly the Deputy Commissioner, respondent number 3, is granted liberty to proceed. The granted liberty to proceed afresh for issuance of the order.
After giving.
In compliance of the order date, in compliance of the government order dated 6/3/2026, after giving adequate opportunity to the petitioner for hearing. Okay. With the above, this writ petition stands disposed of. Okay.
Item number 6.
Yes.
May please, Lordship.
Yes.
Lordship,
Well, may I have the indulgence of making one submission, my lord?
Yes.
In this case, the challenge is an order passed whereby the second marriage permission granted earlier has been withdrawn. And that has been withdrawn on the basis of an inquiry as well as a subsequent consequential order at the instance of his first wife. Now, first wife has not been implicated as a party. First wife, in fact, apprehending such writ petition, filed a caveat also, but she has not been implicated. My submission before your lordship is possibly without hearing the first wife, this order cannot be interfered with. So I'll submit before your lordship that let the writ petitioner make the first wife as a party because she is a necessary party. On the basis of her complaint only the impugn order has been passed, but she has not been made a party here.
Okay. So what is
Malad, I would like to respond to this, Malad. Malad, my basic case is that Malad, there was a permission granted by the authority on an application made by the petitioner. Malad. The petitioner made an application for granting him a permission under the statute, Malad, under the rule that he should be allowed to enter into a second marriage as the personal law permits. Now that application was acted upon by the authority. There was a approval given by the competent authority for granting the permission, and the order whereby the permission was granted is of 24th of September 2025. And that order, my lord, clearly mentions that a formal permission has been accorded to proceed with the customary marriage with the second marriage. Now, if your lordship will kindly see page 75, my lord. Page 75. Page 75 is the order granting me permission to enter into a second marriage. My lord finds page 75.
Yes.
Here, lordship will kindly see. May I just read this order? My lord, very important it is.
Yes.
Dr. So-and-so, by his application dated 16/9/2025, has sought formal permission of the competent authority under Rule 21(2)A of the Central Civil Service Conduct Rules 1964. The Rule 21(2)A of the CCS rules permits a government servant to enter into or contract any marriage if such marriage is permissible under the personal law applicable to the said government servant and the other party to the marriage. As per the service record and the scheduled tribe certificate dated so-and-so is a member of a Nisi community recognized as a scheduled tribe under the Constitution Scheduled Tribe Order 1950. Accordingly, he is covered under the purview of Rule 21(2)A of the CCS Rules 1964. The legal opinion was sought from the Institute Standing Council in this regard, and the council has opined inter alia that the government Arunachal Pradesh, in exercise of the provisions of 21(2)A CCS conduct rules, has issued gazette notification in respect of certain department, namely RWD, Legislative Assembly Secretariat and Home Department. These notifications by implication are applicable to all government department and APST employees, since the government of Arunachal Pradesh has permitted second marriage for APST government employees under the aforesaid provision. The applicant herein is entitled to the same legal dispensation. Now, my lord, to kindly note this, my lord, second part, my lord. In view of the above, based on the legal opinion tendered, the following is hereby ordered. Formal permission under Rule 21(2)A of the CCS Conduct Rule 1964 is accorded to so-and-so, enabling him, my lord, will kindly mark this, my lord, enabling him to proceed in accordance with his personal customary law as contemplated under the said provision. Second, the aforesaid provision shall be duly recorded in his service record for all administrative and legal purposes. The order is issued with the approval of the competent authority. My lord finds this. Now, my lord, now, based on this order, a legal right has accrued upon me to enter into a second marriage, my lord. And accordingly, in pursuance of the permission, my lord, I have entered into a second marriage. That is page 77, my lord, would kindly see.
This was on?
This was on 10th of October 2025.
Okay.
Pursuant to the
marriage was?
Yes. The marriage was already solemnized, my lord. Now, this was again informed to the director, my lord, against whom I am alleging malice, my lord, here.
Okay, where is then come to 97?
My lord, I'll come. Lordship will kindly see page 78. This is 16th October 2025, informing the director regarding my solemnization of second marriage on 10th of October 2025, and the copy of the customary certificate was also submitted before the authority. Now, my lord, down below, lordship finds. Down below in page 75. 78, sorry. 77 is this customary certificate, marriage certificate.
Okay. Issued by?
Issued by the head Gauburas, and it was issued by the statutory authorities, who has been appointed under a statute,
25. Okay.
Now, page 78, it was informed to the director, respond number 4,
Okay.
because he was the one, who has issued the formal order of permission. Thereafter, what has happened, on 18/3, I fell ill and I went to the doctor of the nearest, I was being advised to undergo certain tests, Page 79, will kindly see. But I'm placing this sequence of events, this is very important because I'm alleging malice against the respond number 5, respond number 4, whom I have made him as a party, by name.
Okay.
Now, 18/3/2026, I fell ill. I went to the doctor, I was suggested to go for a bed rest and to undergo certain tests, On 19/3, I applied for leave. I have booked my ticket for Delhi for my treatment, and accordingly on 20th March, page 80, will see the boarding pass. I flight to Delhi, for treatment, 20/03/2026. These dates are very important.
Okay.
Now, page 81, your lordship will kindly see.
Yes.
This is a notice dated 19/3/2026, served upon me on 20th March, through an email by the establishment sale, and the email your lordship will find at page 82. This is dated 20th of March, 2023, 11:34 a.m. My lord finds that in the top. Through this email, a notice was served upon me to appear before a fact-finding committee, the director, on 2nd of March 2026. I have also challenged the constitution of the fact-finding committee because this committee was constituted by the director without any approval from the authority. Now, I was directed to appear before the fact-finding committee on 23rd March. Page 81, lordship will kindly.
Yes.
23rd of March. My leave was till 23rd of March, and thereafter, as I am unable to appear, on 21st of March, page 83, will kindly see, I informed the director that page 83, May I just read this, This is important,
Reply to notice that he is
Yes,
unable to appear.
Yes, this is important, I have placed certain facts here,
Okay.
The first paragraph, that you are aware that I had already applied for casual leave on 19/3/2026 on medical grounds, and to that effect, station leave with effect from 20th March 2023 afternoon to 23rd of March 2026, pursuant to medical advice for undergoing necessary diagnostic test and further consultation as per prescription dated 18/3/2026. That in furtherance of the above, I have booked my air ticket on 19/3/2026 at 9:34 a.m. for travel to New Delhi on 23rd of March 2023. My lord will find that my tickets were booked prior. I have received the notice, my lord. Departure at 14:35 hours from Itanagar in connection with my scheduled medical consultation, and have accordingly proceeded out of station. At the time of making the aforesaid arrangement, I had no knowledge whatsoever regarding the constitution of any fact-finding committee by the order dated so-and-so, and same was never communicated to me. My lord, kindly mark this, my lord. The intimation regarding my appearance was received only on 23/26 by email, which came to my notice only after arrival in New Delhi at around 6 p.m. I was in flight. I received the mail. I've checked my mail. In view of the above circumstances, I regret my inability to appear before the fact-finding committee on the scheduled date on 23rd March 2026, and as I'm out of station for medical physical examination and consultation. I respectfully submit that the circumstances leading to my non-appearance are bona fide, unavoidable and beyond my control. There is no intention whatsoever on my part to evade or disregard the proceedings. It is further submitted, my lord will kindly take note of this, my lord, because the complaints, my lord, which based on the two complaints, my lord, the fact-finding committee has asked my appearance, my lord. These two complaints relates to allegation that I am having an extramarital affair with somebody. I have committed domestic violence on my wife, my first wife. So this has nothing to do with my service as a registrar in the institute, my lord. It is completely domestic in nature, my lord. Now, my lord, will kindly see here, my lord. It is further submitted that the subject matter of the complaint as reflected in the notice and accompanying documents is already under investigation by the competent authority. The complainant has lodged an FIR before the Women's Police Station, Itanagar, resulting in registration of Women PS case number 67 of 2025 under section 351, subsection 385 of BNSS. Pursuant thereto, I have already been issued notice under section 35(3) of the BNSS and have participated in the investigation. The said investigation is presently pending. Further, on the very same set of allegation, the complainant has instituted a proceeding under section 12 of the Protection of Women from Domestic Violence Act before the Honorable Court of Judicial Magistrate First Class, which has been registered domestic violence case number 48 of 2025. The Honorable Court has taken cognizance and by order dated 10/2/2026 has issued notice upon me and granted interim relief to the complainant. The matter is presently sub judice and the pending adjudication before the competent court of law. In the light of the above, it is respectfully submitted that the allegation basis forming the basis of the present fact-finding committee are already a subject matter of a criminal investigation as well as judicial proceeding.
Okay.
Initiation of parallel inquiry. Now, my lord, this was, and in the enclosures, my lord, I have submitted everything to the director.
Ultimately, that was cancelled.
No, that was not
The
cancelled.
permission. No.
No, but what surprisingly, what has transpired, my lord, I have not been informed what was the outcome of the fact-finding committee sitting on 23rd March. I requested this director, my lord, this very director, that give me a copy of the minutes of the fact-finding committee, what has happened and what is the next date of the fact-finding committee. My lord, will kindly see page 85, my lord. And I've also asked for, under what authority you have constituted the fact-finding committee. Now, my lord, in reply, what has been given to me, serial number 2, my lord, will kindly see. The director refused to give me the minutes of the fact-finding committee and he says that a recommendation has been sent, it is confidential. Apparently, my lord, the fact-finding committee did not even hear me. Serial number 2, my lord, in the reply part, your lordship will see, at this stage, the proceedings committee, including the orders of the constitution and internal deliberations, are classified as privileged and confidential official records. Confidential reports is communicated to the chairman, BOM, and the so-and-so government of India. Well, how can it be a privilege confidential, my lord? You conducted an inquiry against me. You are proposing to take action against me. And how can this be a confidential report? Am I not entitled to this? Now, my lord, your lordship will see, now in this serial number 3, my lord will kindly see. To my question, to my query regarding the approval granted by the competent authority for constitution of the fact-finding committee. The reply is, as per the MOA of the institute, the director narrates is empowered to constitute any committee for smooth functioning of the regular activities of the institute. Now, my lord, kindly mark this. However, the details of the fact-finding committee was informed to the chairman of the BOM and the MOE. Now, my lord will kindly come to page 58, my lord. What is this power which he is referring to, my lord? Page 58. Before that, my lord, page 56, my lord, will kindly see who are the officers of the institute, my lord. This is the, my lord, rules of the institute, my lord. Following shall be the officers of the institute, the director, the registrar, my lord, the petitioner, that is, and the finance officer and other officers. Page 56.
Yeah.
14, my lord, finds serial number 14. Officers of the institute.
Yes.
The following shall be the officers of the institute. Director, number 2 is the registrar, who is the petitioner, my lord. the finance officer and others officer as may be prescribed in the bylaws. Now, my lord will kindly come to page 58 is the only power to the director for constitution of committee, my lord, which he says that though no approval has been given, I have been empowered by the rules of the institute to constitute committee, my lord. Now, what does this rule says, my lord? The director may, if he is of the opinion that the immediate action is called for any matter, my lord will kindly see. If immediate action is called for any matter, exercise any power conferred upon any authority of the institute under the memorandum of association and the rules and the regulation, bylaws, take such action or proceed to take such action and shall report to the concerned authority on the action taken by him, her on such matters. Provided that if the director is of the opinion that such action ought not to have been taken, he or she may refer the matter to the chairman, board, management, whose decision thereon shall be final. Now, my lord, this provided further that any person in the service of the institute is aggrieved by the action taken by the director under the said clause, he shall have a right to appeal against such action to the board of management within 30 days from the date on which such action is communicated to him or her, and thereupon the board of management may confirm, modify or reverse the action taken by the director. Now, my lord, I was aggrieved by the constitution of this fact-finding committee, the manner the fact-finding committee proceeded under at the behest of the director, my lord. Being aggrieved, my lord, I preferred an appeal, my lord. Now, your lordship will kindly come to my appeal, my lord, page 91.
Yes.
Lordship will it's a appeal dated, my lord will kindly mark the date 10/4/2026. It's very relevant because this date is very relevant, my lord.
Yes.
In 10/4/2026, now my lord will come to page 93. Serial number 7, my lord.
Yes.
That to utter shock and surprise, the director by its letter dated 28/3/2020 refused to furnish the proceedings of the committee, including its constitution and internal deliberation, classifying the same as privileged and confidential report, but mentioned that the confidential report is communicated to your kind self and the MOE, Government of India. It is highly surprising as to how the so-called fact-finding committee, which apparently has been constituted without any approval from the board, has submitted its report without affording any opportunity of being heard to the appellant, despite the appellant had duly informed on 21/3/2026 about his inability to appear on 23/26. The report of the committee is in sheer violation of the principles of natural justice and also establishes the unfairness and the malice involved behind this inquiry. By the reply dated 28/3, director do have asserted his power to constitute any committee for smooth functioning of the regular activities of the institute. But apparently the constitution of the fact-finding committee to inquire into the allegation level in 2 complaints submitted by the appellant's wife. It is clear that the allegation sought to be inquired has no connection with the smooth functioning of the regular activities of the institute. And the same relates to personal and domestic relation of the appellant with his wife. Above a party committee, after having informed about the pending investigation on the same set of allegation as well as the pending before the Honorable Court of JMFC, had no jurisdiction to make any inquiry behind the back of the appellant.
Also constituted based on the complaint submitted by the wife.
Two complaints.
Yeah, you need to impede the wife.
No, Malab, I'll come to that, Malab. Malab, I am challenging this impugn order primarily on the ground, Malab, that there was a permission which has conferred a right upon me to conferred a right to enter into a second marriage. That permission was withdrawn by the director after I have submitted this appeal. Well, that is one point that I'm alleging malice against him. Second, my lord, he has withdrawn the permission based on certain complaints. This is not just 2 complaints, my lord. There are other complaints in which I have never been given a notice, no hearing, not even an intimation that some action proposing to
complaints, not only 2.
Many complaints, my lord. And I have never been informed about this complaint.
And then there is an allegation also that you have you did not disclose at the time of informing.
If that be so, if that be so, my lord, my respectful submission would have been is, my lord, if there is an allegation that prior permission, I have entered into a second marriage. then this act of mine constitutes a misconduct under the rule, my lord.
Yes.
I should have been so cause for explaining the misconduct. Now, my lord, my subsequent permission, what they say in the order, my lord, I have not disclosed about my primary permission. Now, my subsequent permission, which was accorded on 24/9/2026, cannot be a ground for justify that misconduct, my lord. That cannot be a ground for cancelling my permission. Now, they do not have anything to establish this fact that there was a marriage prior to the permission, my lord. And therefore, as a tool to use it as a misconduct against me, the permission has been withdrawn. Now, my lord, this permission has, the withdrawal of this permission has a civil consequence upon me. Not just me, my lord, the second wife as well. Did the authorities issue any notice to the second wife, because based on their permission, they have allowed a girl to enter into a marriage with me?
See,
what would be this?
Prior to granting permission,
that I have denied.
there was already a complaint.
No, there were complaints.
And then you
Had I been given an opportunity to make my submissions on that complaint, but it's a gross violation of principles of natural justice, my lord. And why this has been done, my lord, behind my back? And my lord, very interestingly, if your lordship will see, this is an administrative order of the director. If I see, it is an administrative order of the director. Now, against this administrative order, how the director is personally, my lord, prejudiced, my lord, if a writ petition is filed? Director files a caveat. Parallelly, the wife also files a caveat. But I'm alleging malice against the director, that the director, in connivance with the first wife, has behind my back taken this action so that they can prejudice me. I have made a categorical allegation in this petition.
you implead the wife also?
No. Till that time,
my learned friend has made elaborate submissions on merit, my lord. Only one submission making, whatever may be the illegality in the order, if the impugn order is, my lord, interfered with without hearing the person on the basis
No,
of
I'm
which
not asking for an interference today, my lord. I am saying, my lord, based on this impugn order, my lord, I apprehend, my lord, this impugn order has been passed to use a tool against me to prejudice my service, my lord. And therefore, my lord, I will implead, my lord, let the parties file their affidavit also. Till that time, my lord will protect me, say that there should not be any coercive action against me, my lord.
You first implead.
My lord, may I make one submission? My lord, may I make one submission? My lord, may I make one submission? Without the wife, the writ petition is not maintainable for not impleading the necessary party. My lord, writ petition is not maintainable. How can you pray for an interim order where the writ petition itself is not maintainable? On this ground alone, writ petition has to be dismissed because it is not maintainable. My lord, lordship is aware of the judgment of Malparia, my lord, reported in 1963 Supreme Court, page 786. I am just reading one paragraph from there. This writ petition is not maintainable. Lordship cannot grant any relief to them, far less any interim order, my lord. My lord, paragraph 6 reads like this, my lord. The question is whether in a writ in the nature of certiorari filed under Article 226 of the Constitution, the party or the parties in whose favor a tribunal or authority had made an order which is sought to be quashed is or are necessary party or parties. While learned additional Solicitor General contends that in such a writ, said tribunal or authority is the only necessary party and the parties in whose favor the said tribunal authority made an order or created rights are not necessary parties but may at best be only proper parties, and that is open to this court, even at this very later stage, to direct the impleading of the said parties for a final adjudication of the controversy. Learned counsel for the respondent contends that whether or not the authority concerned is a necessary party, the said parties would certainly be necessary parties, for otherwise the High Court would be deciding a case behind the back of the parties that would be affected by its decision. If your lordship interferes with this order, my lord, which has been passed, if your lordship goes to the impugn order, just one moment, my lordship may kindly turn to page 97. I'll show what the impugn order has mentioned. My learned friend has pointed out the impugn order. Page 97.
I was coming to page 97.
Yes,
my lord, page 97. Just lordship, just 1 minute, my lord. In reference to the office, lordship has got, my lord.
Yes, yes.
In reference to the office order number so-and-so, whereby permission was accorded in so-and-so for contracting a second marriage under rule so-and-so, whereas multiple complaints along with supporting documents have been received from Mrs. Toko Yajur, the legally wedded first wife of Dr. M.K. Kamdir, by her communication dated so and so, so and so, and so and so. So many complaints were raising serious objections to the said second marriage and requesting initiation of appropriate disciplinary proceeding. And whereas the matter has been re-examined in the light of the said complaints, subsequent developments and the legal opinions obtained, and where it has been obtained that aforesaid approval was accorded without proper verification of material facts, including non-disclosure of the prior solemnization of the second marriage on so and absence of prior permission as mandated under Rule so, and whereas it is further established that proposal was processed based on incorrect application of the relevant rules and without due consideration of the complaints representation received, and whereas it has been observed that the office order dated so, there is the permission, my lord, is not in consonance with the approval accorded by the Chairman Board of Management, which it stipulated approval as per rules, Government of India, and therefore suffers from material irregularity, and where this is important. Whereas upon obtaining legal opinion from the learned Additional Advocate General, Government of Arunachal Pradesh, it has been opined that no exemption is permissible under Rule 21 of the CCS Conduct Rules 1964, and that contracting a second marriage without prior permission constitutes misconduct. This is the order, my lord. Now, therefore, the competent authority, after due and careful consideration of all the facts and circumstances of the case, hereby orders that officer so and so stands withdrawn and cancelled. So, my lord, on the basis of my complaints, it has been done. Now, one question may arise whether my complaint is relevant or not, because their personal custom permits. My lord, the provision under which the permission was granted, that is Rule 21 of the CCS Conduct Rules 1964, my lord, has got two things. One, any such permission can be granted if such marriage is permissible under personal law applicable to such government servant and the other party to the marriage. And, my lord, that is also important. There are other grounds for so doing. So, on the ground of any complaint by the first wife, if this is not permissible to grant a permission, authority may not grant. And therefore, her participation, her complaint is relevant. I am not arguing today on merit matter. I am only saying that when the order was passed based on my complaint, I am a necessary party. Please implead me and then pray for an order. Today, your petition is not maintainable for not impleading the necessary party. But it is very clear in the Civil Procedure Code also. Non-joint of necessary party strikes at the root.
You first implead.
My lord, kindly.
It will be difficult to issue
Yes,
notice.
I understand, my lord, what my lord senior has said, my lord. In fact, my lord, from the order, my lord, is there any whisper as to that only these complaints I was ever been informed?
That is on
My lord,
merit.
I'm challenge, my lord, that I'm challenging. My lord, it's a violation of principles of. My lord, whether the wife is a necessary or a proper party would be decided by this honorable court, my lord.
Yeah.
In my respectful submission, my lord, it is a proper party, my lord. It's not a necessary party because when this permission was granted, did the authority take the consent of the first wife? If she is a necessary party. Now, the Rule 21(2)(a), the interpretation of other purpose, as has been projected, that other purpose means the first wife. Whether this was a consideration while granting the permission, it was never, my lord. Now, rightly, wrongly, there was a permission accorded. Now, my lord, why this permission hurriedly has been withdrawn, my lord? Your lordship will kindly appreciate that, my lord.
Now the purpose.
The purpose is, my lord.
The ground for withdrawal is the complaint lodged by the wife.
Yes,
only.
my lord.
Right.
Yes.
Right.
So you.
She is a necessary party.
There are two things. In the impugn order, your lordship will kindly see the opinion of the learned Advocate General indicates the, my lord, the tool, my lord. Why I am apprehending, my lord? I have no difficulty, my lord. Your lordship will take up tomorrow morning. I will implead the wife as a party. I will file my application
All right,
for
let
impleadment.
him make her a party and let it be taken up tomorrow, my lord.
Yes, sir.
Mr. B. Kausik, Land Council for the petitioner. Some is that
Yeah, but people issue now there.
at the time of filing this writ petition, the wife of the petitioner has not been impeached. Therefore, he prays for allowing him to impede the wife of the petitioner, writ petitioner, as a party respondent number 6 to the writ petition. Okay,
Hello.
the prayer is allowed.
Lordship will take up tomorrow.
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 Okay, but you have to.
Well, I'll file my application.
Amen.
No, I'll file my application, my lord. The Lordship, because there, my lord, if Lordship protects me, my lord, see, the wife is concerned about the interference with the permission, my lord. What my learned senior is saying, that she is a necessary party, so there cannot be an interference to this order. But what I'm praying for, there may not be any coercive action against me. Lordship will take up this matter
tomorrow. We'll take up tomorrow.
Well,
My lord, tomorrow your lordship will consider, my lord.
tomorrow.
Okay.
Well, I'll make a mention in the morning, my lord, with regard to the application. I'll file, my lord.
Okay.
So,
Or
so
my
that
lord,
your lordship can take.
may I make a my lord, suggestion subject to my learned friend's convenience or in the honorable court's convenience, my lord? Can it be taken up on 13th? My lord, I'll physically be present there. My learned friend also can be there on 13th. This honorable court
Well, I
is
have no
sitting next
difficulty,
week,
my lord. Provided, my lord, if my learned senior agrees, my lord, let there be a protection, my lord, as to that there will be no coercive action, my lord.
That will see you.
No, my
My
lord, no
lord,
coercive action is
let the
not going.
petition be maintainable
No, my
first.
lord,
It is
tomorrow
not
morning, my
maintainable
lord.
today, my
Let
lord.
it, my lord, let it be tomorrow morning, my lord. Let me place my case on merits, my lord. Let me place my case for interim order.
On Monday.
Huh?
My lord, Monday I've got some difficulty.
Friday.
13th, I
Okay, 13.
But 13 would be labeled because your lordship is not protecting me.
Hmm.
If your lordship at least protects me that no coercive action will be taken by the respondent authorities.
Then let it be on Friday, my lord. Let it be on
Tomorrow,
Friday.
tomorrow, my lord. Tomorrow, my
All
lord. Well, let me, because my learned senior has made a technical point that she should be implemented. So let me have that opportunity of implementing her.
Okay.
Lordship will decide it.
Okay.
Tomorrow, man.
Tomorrow. Okay.
Grateful, my lord.
This is matter again tomorrow.
Item number 9.
My lord, in this case, my lord, I require to file the affidavit, my lord, may be granted 2 weeks time, my lord, to file.
Mr. T. Dogon, Standing Council for the Education Department.
Yes, ma'am.
Prays for and is granted for 2 weeks time to file affidavit in opposition. Staff. Mr. A. K. Singh, Land Council for a petitioner, is also present. He has prayed list in this matter after 2 weeks. Okay.
Deeply.
Item number 10.
Please, your lordship.
This matter seems has been already been admitted, it appears.
It is admitted, my lord.
Then in that case, it has to be listed for hearing. Where is the?
Lord, it's a matter of termination of a cook, my lord.
Okay.
So, my lord, anyways, my lord, I think, my lord, pleadings are otherwise completed. Well, as for the grounds which I have taken in this repetition, my lord, that I was never been given a hearing.
Okay.
So, my lord, perhaps in my respectful submission, my lord, the records of the proceeding would be relevant. The departmental proceeding would be relevant, my lord.
So that need to be called for.
Yes, and my lord, instead of putting it for hearing, my lord, it's a poor cook, my lord. So lordship can take up for disposal in the admission.
Give a date then, in
Yes,
that
ma'am.
case. But
Yes.
since it has already been admitted, why to list it again and again in the admission column?
Let it
We'll
be,
give you date.
my lord. Let it be in the
At your
admission column, my lord.
convenience, okay? Mr. Kaushik, Land Council for a petitioner, some state. In this case, the records of the proceeding would be necessary for proper adjudication of the case. In view of the above, you can produce a record,
Yes, your lordship.
Mr. Ram Lan Government Advocate. Will produce the connected records, record of the proceedings.
Record of the departmental proceeding.
A record of the department proceedings against the petitioner on the next date. Okay, the next date is
Can it be a 20th of May, my lord?
is
20 May.
List this matter on 28th of
20th of May,
28. Okay,
20.
okay. For hearing, huh? For hearing.
For disposal hearing.
It's for hearing.
My lord.
Let us.
Oblige.
Yes.
Item number 11.
May I please answer?
Yes.
My lord, in this case, my pleadings are complete, my lord.
Okay.
My lord, I am praying for disposal of this case, my lord. My lord, since petitioner is suffering since 2024, August 2024, my lord.
Okay, what is this matter about?
My lord, in this case, my lord, petitioner is asking for twofold, my lord, relief, my lord. First, my lord,
asking for
twofold relief, my lord. There is
Okay.
two relief has been sought by the petitioner, my lord. First, my lord, for rewarding her back to her original post, which she holds prior to her regularization, my lord. And
case of regularization.
not exactly, my lord. And then second is, my lord, regarding her back wages, my lord, since from August 2024, my lord. My lord, so I will take your lordship to the facts which leading to filing of this writ petition, my lord. My lord, may I take your lordship to page 13, my lord, Annex 1. My lord, in the year 2016, my lord, petitioner was engaged in a skill contingency under the District Agriculture Office, sir, 0, my lord.
Okay.
Page 13, my lord.
Page
13, my lord. She was engaged as skill contingency.
So who appears for the other side? Okay, for the department.
For the department, my lord.
Okay.
I
And
for private respondent.
there is a private respondent also.
Yes, my lord.
Okay, for the government. Needs here, otherwise needs hearing, no hearing, or just can be heard today.
My lord, it's very, I think, my lord, not so complex. It's, my lord, small matter.
Some hearing will be required in this case.
Now the petitioner are asking my place, lordship. I have been promoted, regularized in her place.
Okay.
After dismissal from job,
Okay.
now she is claiming back my post, lordship. Where I will go?
My lord, sir, let me explain, my lord. Let me explain, my lord. Well, this is, my lord, a short matter, in my humble understanding, my lord, very short matter, my lord. My lord, in the year 2016, my
Let us
lord,
just see if it is, if you you feel that it will take a little longer time, then we'll fix another date for hearing.
my lord.
If it is going to take long time.
Yes, my lord.
But let us see just, huh?
My lord,
He was appointed as
skill contingency under the Department of Agriculture, 0, on 2016, my lord. In the year 2016. Thereafter, my lord, what happened in the next page, page 14, my lord. In the year 2019, my lord.
She is posted at 0.
0 only, my lord.
Okay, next is?
Yes, my lord, page 14, my lord. My lord, in the year 2019, my lord, a DPC, my lord, departmental committee meeting was conducted, my lord. And my lord, in that departmental committee meeting, my lord, all the contingency staff who are serving under the Office of District Agriculture Officer 0, my lord, they have been considered, my lord. And on the basis of, my lord, the merit of the performance of the candidates, my lord, contingency candidates, my lord, this petitioner was recommended for regularization to the post of regular peon, my lord, in the year 2019. And this order, my lord, 18 June 2019 order is a departmental recommendation order, my lord. After conducting DPC, she was regularized to the post of on the recommendation of board committee Srimati such and such under the establishment of deputy director.
It's a regular order of regularization.
Yes, my lord. She was regularized, my lord.
Yes.
Thereafter, my lord, what happened, my lord? This regularization order of the petitioner, my lord, has been challenged by one of the contingency staff of the district agriculture officer. And next page, page 15, my lord. Page 15 is the order of this honorable court, my lord, passed on, my lord, 02/06/2023, my lord. By this writ petition, my lord, my regularization has been challenged before this honorable court. And this honorable court, my lord, by this order dated 02/06/2023, my lord, interfere my regularization, and my regularization order has been set aside and quashed, my lord.
Your regularization set aside.
Set aside. Because, my lord, it is not done as per the relevant recruitment rules, my lord. That is not disputed, my lord. I'm also not disputing, my lord.
Okay.
Thereafter, my lord, appeal has been prepared by the petitioner, the present petitioner, before the coordinate division bench, my lord. And same is also dismissed, my lord. Next page, page 35. Same was also also dismissed, my lord. And she also goes up to the Supreme Court, my lord. But the Honorable Supreme Court also did not interfere with the judgment order passed by the latter single judge, as well as the writ, judgment order passed in writ appeal, my lord. My lord, that is not disputed fact, my lord. Now, my lord,
Where is the order of SLP order?
SLP, my lord, page 54.
54.
Yes, my lord. Just one page order, my lord.
Okay.
We are not inclined to interfere with the impugn judgment and order passed by the court. My lord, thereafter, my lord. Now, my lord, main grievance of the petitioners comes up, my lord. Now, the petitioner, my lord, by this recommendation of the DPC, she was promoted, she was regularized to the post of regular peon, my lord. And that has been interfered with by this honorable court, as well as by the division bench of this honorable court. Now, my lord, what the department ought to have done, my lord, she would have been rewarded back to her original post of skill contingency, my lord. But department till that neither revert back the petitioner to her original post of skill contingency, nor any wages has been paid to the petitioner since August 2024. But she is working.
She is still working.
She is still working under the Department of Agriculture 0 without any pay and status, my lord. That's why.
Name is in the rules.
Yes, my lord. I'll show your lordship to that also, my lord. My lord, kindly come to the page 58, my lord.
There is no termination otherwise.
No, my lord, my skill contingency, I was initially appointed as a still contingency, my lord. That has not been, my lord.
After setting aside and quashing of your regularization order, what order was the passed by the department?
No order has been passed, my lord.
Then how it was made? How it was made applicable?
My lord,
who presented the order or the High Court order or the High Court or Division Bench order?
Yes, my lord. My regularization order that has been terminated by. That has
There
been
is a
terminated.
Where is that order?
That is it in the affidavit in opposition, my lord.
Didn't say anything about your.
No, my lord. Kindly, my lord, come to their affidavit in opposition, my lord.
Affidavit in opposition filed by
My lord, respondent number 1, 2, and 4.
Okay.
My lord. Page 72. Page 72, my lord. May I read, my lord?
Just a minute.
Srimati, page 72.
72.
Yes, my lord. Order dated 31st July 2024, my lord. Srimati such a charge, peon under the establishment of district agriculture officer, Lower Subansiri district is hereby terminated, discontinued from her present post of peon with effect from 1st August 2024 as per the Guwahati High Court. It's another permanent bench judgment.
Okay, so the present post of peon means the
regularized post, my lord. But I'm not asking for the regularized post, my lord. I'm asking for my original post, my lord, from where I was been regularized, my lord.
Okay.
Yes, my lord. My lord, my contention and the grievance of the petitioner is only that, my lord, since my regularization was done by the department and it was interfered with by this honorable court, my lord, and I have been discontinued from the post of regular peon, my lord. I should have been, my lord, revert back to my original post, that is skill contingency, which I was appointed in the year 2016, my lord. That is the main, my lord, prayer of the petitioner in this writ petition, my lord. Now, my lord,
Okay.
now, my lord, in the normal parlance, my lord, as your lordship knows, my lord, hypothetically, if I submit, my lord, suppose, my lord, if a person, suppose, my lord, if a junior engineer is promoted to the post of assistant engineer, my lord, but his promotion has been, my lord, cancelled or interfered with by the honorable court, my lord. Now, my lord, in common parlance, my lord, he should be reverted back to his original post, my lord, that is junior engineer, my lord. That is my claim only, my lord.
There is no order as such.
As such, my lord.
Okay.
And thereafter, my lord, further, my lord, if you also come to page 58, my lord, of my writ petition, my lord. order dated 29th May 2025, my lord.
Hmm.
My lord, my lord would find in serial number 1, my lord, as well as in serial number 5, my lord. The department is availing my service as a contingency.
What is this order?
This is regarding in partial modification of earlier order dated such and the following group D and contingency staff of this establishment is hereby directed to perform their duties as indicated below with immediate effect, my lord. My lord would file my name in serial number 1 as well as in serial number 5, my lord. 1, my lord, Srimati Hage Yavang contingency staff. And my serial number 5, Srimati Hage Yavang Xerox operator contingency staff, my lord. Why I'm, my lord, taking your lordship to these documents, my lord, is that, my lord, though she was not rewarded back, there is no order as such, my lord. Though she was not rewarded back to her original post, but her service has been able by the department as per record, I will say, till 29 May 2025, my lord. After filing of this petition, my lord, they are availing my service, but they are not paying me the wages, my lord, which is required to be paid to a contingency staff as per the norms of Government of Arunachal Pradesh, my lord. That is my second, my lord, grievances, my lord.
Okay.
Now, my lord, as I submitted already, my lord, once my regularization is, my lord, cancelled or is interfered by the Honorable Court, and it has been discontinued, my lord, ordinarily, my lord, I have to revert back to my original post, that is skill contingency, my lord. In the case, my lord, that has not been done by the department till date, my lord. Therefore, I call for interpretation of this Honorable Court. And second, my lord, till, my lord, 29th May 2025, my services has been availed, my lord. Availed by the department, but no wages has paid to me since August 2024, my lord. My lord, after my discontinue also, my lord, they are availing my service, my lord. My lord, my lord has seen page 72 of the affidavit of opposition, my lord. This discontinuation was done on 31st July 2024, my lord.
Yes.
And my services was availing till 29 May 2025, my lord, as a contingency, my lord, skill contingency, not as a regular peon, my lord. That is admitted back, my lord. Therefore, my lord, it is the humble prayer of the petitioner before this Honorable Court to issue a direction to the respondent authority to revert the petitioner back to her original post of skill contingency, and she should be directed to, the respondent should be directed to pay the, my lord, the wages which she entitled as per norms of Arunachal Pradesh, Government of Arunachal Pradesh. That's all, my lord.
Just a minute. Let us see your prayer.
My lord. My prayer is, it is
okay.
10.
Okay.
Page 10, my lord. 1 is to revert the petitioner back to her original post.
Okay.
Second is directing to pay the salary.
So, what about now at the moment? Presently, she is in the service.
She is attending the office without any salary and
Okay.
status, my lord.
Okay. Yes. So, yes.
Now, in our opinion, my lord, we turn to page number 68, my lord.
Just a minute, sir. For respondent number?
Official respondent, my lord, they have 1, 2, and 4. 1, 2, and 4.
Yes.
Annex number is page number 68, my lord.
68.
68, my lords.
Yes.
This order, my lord, in the interest of the public service, research and unskilled contingency is hereby appointed as the skilled contingency with effect from 16th or 19/6/2019 against resultant vacancy of Srimati such and such who has been regularized to the post of regular field, my lord. Now, immediately after his regularization, my lord, the post, my lord, were filled up by, my lord, the private respondent here in, my lord. Yes, now, after that, my lord, again at page number 69, my lord, annex number B, my
Just a
lord.
minute, huh? Page 68.
69, my lord.
C is a respondent.
Respondent,
Respondent number?
5, my lord.
Page 68 is respondent.
Next page, my lord, it is annex number V, my lord, page 69, my lord. In the interest of public service, research and such unskilled contingency is hereby appointed as a unskilled contingency night jockey that will pay against the resultant vacancy of such and such. This is respondent number 5 again, my lord, who has been regularized for skilled contingency, my lord.
Okay.
Now, vacant, all the posts, my lord, has been filled up, my lord. And now, in such this, I believe this also is been necessary party, my lord, if my lord pass any order, my lord. in
He
this
is
case.
not a necessary party, Akbar.
No, he is not a party in this case, my lord. If suppose, my lord, today pass any order, my lord.
No, the who has been promoted or given the post of the regular post
Regular.
created by the petitioner by way of termination, who has been appointed there?
In regular post, my lord. Nobody, my lord, not yet.
Not yet.
Regular.
Okay. Then what is the criteria for appointment to the regular post?
Regular post, there should be DPC, my lord. DPC and
Can be created, one senior most can be given to regularize, and that post, they will be there. That arrangement can be made. Nobody will be out. Isn't it?
my lord has right. Yes, my lord. If the post is vacant, my lord, I need to take instruction on that, my lord. If whether that particular post, my lord.
Because that post is still lying
Maybe,
vacant.
my lord. If not, fill up, my
Who
lord.
is entitled or whosoever is senior most,
My lord.
let a DPC conduct
My lord.
within within short period, and then let her be appointed, and so that this Pagmar also doesn't go, and then one Dani also doesn't go.
Yes, ma'am. That can be. So
That can be.
For that, my lord will give me some time, my lord, so that I can accurate instruction, my lord.
That will be better.
My lord.
Okay, so that way, and otherwise direction also will be in that way only. Because there is no order discharging her from the contingent.
Yes, ma'am.
Only the regular post, her regular post is gone. This, there should have been an order reverting her back to the original post because the promotion was illegal, not the first appointment as a contingent.
Yes,
Not
ma'am.
the first. And then since the person has already been appointed, they should also be protected actually,
Protected.
the respondent. So obtain instruction that in that case, when do we fix? How long it will take? Tomorrow.
Tomorrow, day after tomorrow, my lord.
Okay. Supposing if it comes in the form of the written document,
My lord.
you file it on the basis of that,
My lord.
that giving some certain time,
My lord.
say sufficient time to the government.
Yes, my lord.
to
that
pass
would be-
necessary order.
Right, that would be better. Then at least 1 week then.
Get it 1 week.
My lord.
We'll fix just after 1 week.
My lord.
Okay. So, heard Mr. Lampu, huh? Mr. Lampu Lane counsel for the petitioner also heard all of them. Okay. And at this stage, Mr. Liz L. Parme, Parme is a standing counsel for the department.
Agriculture department.
Standing counsel for agriculture department. Some is said. He 1 week time may be granted to him to obtain necessary instruction regarding any appointment against the vacant post created by the petitioner by way of her termination. Okay.
That it will written instruction, my lord.
Okay.
Written instruction.
Obtain a written instruction, huh? Okay, the prayer is allowed. This matter. 13, madam. May 13. 13 is okay. Is it okay?
Okay.
13 May.
May, my lord.
No,
Wednesday.
13 is Wednesday. Okay. Okay.
Oblige.
This is
Deep
oblige
oblige.
on 13.
Item number 12.
Yes. Staple there. Okay.
Your Lordship, the present writ petition raises a very narrow but significant issues whether an executive authority can refuse to implement the final and binding order, despite being no stay, no challenge, and no pending proceedings. Your Lordship, may kindly come to the page number 18.
Just a minute, sir. Just a minute.
1.8, Annexure 2.
Just a minute. What is this matter about actually? Okay, 1A.
1.8,
Page.
page number 1.8, 18, Annexure 2.
Yes.
Yes, may I?
Yes.
Yes, this is the order, this is a decree order passed by the executive magistrate. Your
Executive magistrate passing decree order when?
It's in 2023.
Decree passed.
Yes. May I read, Your Honor?
Yes.
Civil suit number so and so, subject.
Executive magistrate.
Yes, executive magistrate. Your Honor, I will read out
Okay.
the contents. Subject, land dispute case among Hemi clan, Hedu clan versus Ningyo clan.
Subject?
Subject, land dispute case.
It says civil suit.
Yes. Yes. I will go through it.
Yeah, that is why. This is first question.
Yes, Your Honor, I will read out. Yes.
Okay.
Executive order under section 4, clause 1, clause 2, subclause A and B of the Arunachal Pradesh Civil Codes Amendment Act 2022. Whereas Kebang Committee Village Authority was constituted for the trial and settlement of the land dispute in between Hemi clan and Hedu clan, wide order so and so versus Ningyo dated so and consecutive, upon which the Kebang Committee Village Authority have tried the case at length by visiting the spot and hearing both the parties, thereby giving sufficient opportunity to both the parties. As a result, the Kebang Committee Authority have arrived to a final decision settlement of the case on 26/4/2021, and copy of the final decision settlement has been submitted to the office of the undersigned. In the Kebang decision settlement, it has been declared unambiguously that, so we came to conclusion that this disputed land from Pampam Yarlo to Bo Sokong belongs to both brothers, that is Hemi Hedu clan community. Further, an application has been submitted by Sri Taber Hemi, General Secretary, Hemi Clan and Management and Development Committee, and Sri Gopal Hemi, Vice President, Hemi Land Management and Development Committee, requesting this office for execution and enforcement of the order or decree passed by the village authority as per relevant section of the law, since due to the pendency-like situation of the case, there may be breach of peace which may further affect other developmental activities and peace and tranquility of the area. Therefore, deriving strength from the section 4 clause 1 to clause A and B of the Arunachal Pradesh Civil Codes Amendment Act 2022, and also in order to maintain peace under section 145 CRPC, this executive order is hereby issued and enforced as per the decisions of the village authority Kebang Committee dated so and so. The land in dispute from Pampang Yarlo to both Sokong shall belong to both brothers, that is Hemi clan and Hedu clan, given under my hand and seal on this 25th August 2023. Your Lordship, as per the Executive Magistrate Order dated 25/8/2023, has conclusively settled the title and apportionment, Your Lordship. This order has been attained finality, Your Lordship. There was no challenge, no stay, and no pending proceedings, Your Lordship. Now, Your Lordship, after that, after 3 years, like 2023, this has been passed. After that, the concerned authority directed to submit the joint resolution to both the parties for disbursement of the compensation amount, Your Lordship. But the Hedu clan refused to do so, because in the joint resolution should be submit to disbursement of the compensation amount, but they refuse to do so. Because of that only, we have to submit one letter to the authority, concerned authority, that it's kind of complaint. It's in page number 19, Your Honor. Page number 19. Annex number 3. This is a complaint letter we have submitted to the Deputy Commissioner, the concerned authority, stating that the other party is not ready to submit the joint resolution. And here, Your Lordship, we have also annexed the order dated 25/8/2023. And after that, on June 30, 2025, after our complaint, on June 2025, Your Lordship, it's in page number 21. 21. Yes, this is the notice, Your Lordship. The Deputy Commissioner issued one notice. I would like to read the last para only, Your Lordship. Therefore, you are hereby summoned to appear in person or authorized person in the undersigned office chamber on 8th July 2025 at 11 hours to clarify the matter of the said community land. So this notice has been sent to both the parties, that is both the brothers, that is Hemi and Hedu clan. After this, on
Continue at 2.
sorry.
We'll
Yes.
continue at 2. Yes.
Yes, Your Lordship. So, Your Lordship, this is the execution order actually. The DC one, the DC one, the executive magistrate one.
Executive magistrate order is the
Execution, yes.
execution order.
Yes. To page number 18.
Okay.
I would like to read from the second para, second last para. Further, an application has been submitted by Sri Taber Hemi, General Secretary, Hemi Land Management and Development Committee, and Sri Gopal Hemi, Vice President, Hemi Land Management and Development Committee, requesting this office for execution and enforcement of the order or decree passed by the village authority as per relevant section of the law, since due to the pendency-like situation of the case, there may be breach of peace, which may further affect other development activities and peace and tranquility of the area. Therefore, driving strength from the section 1 clause, section 4 clause I, section 2 clause A and B of the Arunachal Pradesh Civil Code Amendment Act 2022. And also, in order to maintain peace under section 125 CRPC, this executive order is hereby passed and enforced as per the decision of the village authority Kebang Committee dated 26/4/2021. The land in dispute from Pampang Yarlong to Bo Sekong shall belong to both brothers, that is Hemi clan and Hedu clan.
What this 412AB says?
It says
for the Civil Code Act, Amendment Act.
This one.
Civil Code Act.
It says the government may by
Do
notification.
we have the copy?
Yes. Which year?
Amendment
Yes.
2022.
22 है ना ये? आप निकाला वाला? हाँ. सर हमको देना.
सिविल कोड एक नहीं है मेरे पास.
नहीं है क्या? क्या है बोला? यहाँ में है हो जाएगा. आगे आपको अंदर क्या
Hmm? 4-1.
ini ना.
There is no such amendment, Malad. There is no such amendment, Malad, as reflected in the order, Malad. The amendment has been made in the regulation, Malad, not in the Civil Code Act. Wrong law.
Civil Code Amendment Act 2022.
Yes.
So the amendment has been made. The 20. This is amendment.
Yes.
Execution and enforcement of the order or decree passed by the village authority.
Yes, yeah.
It is an amendment of section 45, Malad. AFR, of AFR.
Of the Assam frontier.
Yes, yes.
The wrong law has been quoted.
No, it says that it's amendment.
Yes.
Amendment is the amendment of regulation, Malad, section 45.
Of the
Amendment.
Arunachal Civil Amendment, Civil Code Amendment 2024. Okay, yes.
Yes, and your lordship, so after that, after this order has been passed by the magistrate and the deputy commissioner, the concerned authority instructed to submit one joint resolutions from both the parties, but for the disbursement of the compensation amount, Your Lordship. But the Hedu clan refused to do that, Your Lordship. So because of that, we have to submit one complaint letter. It's in page number 19.
Page 19.
Yes.
Okay. This is thereafter the okay.
Yes, that is the order of 2023. They have not challenged any regarding against this order passed in 2023, Your Lordship. And after that, this concerned authority instructed them to submit a joint resolution, but the Hedu clan refused to do that. Because of that, only in
Where
page
is that asking for submission of the concerned authority asked to both the clans to submit what?
yes, joint resolution. It was joint resolution to disbursement of the
Where is
compensation amount. Your Lordship, it was from orally, I guess, Your Lordship. To submit, it was orally. They instruct the authority, the deputy commissioner, instructed them to submit a joint resolution for the disbursement of the compensation amount. Then
Have you stated
yes,
or made an averment to this effect?
sorry, Your Lordship.
Have you made any averment in your petition, writ petition to this
Yes,
effect?
it must be there, Your Lordship. So, Your Lordship, after that, on 19th, we have submitted one complaint letter to the concerned authority that the other party refused to submit the joint resolution. And we have annexed, bring the order copy of 25/8/2023 along with the complaint letter. After this complaint letter, Your Honor, after this complaint letter, may kindly come to the page number 21.
Page 21.
Yes, page number 21, Your Honor.
Yes.
So this is the notice issued by the concerned authority, Your Lordship, the deputy commissioner. So this notice issued on
This notice was issued in the complaint lodged by you.
yes, yes. So on 30 June 2025, I would like to read the last para only. Therefore, you are hereby summoned to appear in person or authorized person in the undersigned office chamber on 8th July 2025 at 11 hours to clarify the matter of the said community land.
Okay.
Yes. After that, on 8th, there were a meeting. Someone has been sent to both the party, to the Hemi clan and Hedu clan. So on 8th, during, yes,
This is page 21A.
this is 21, this is a notice.
Okay.
Yes, notice issued by the deputy commissioner
Okay.
for the meet. Sorry.
After that?
After that, the meeting was conducted on 8/7/2025, Your Lord.
Page?
It's in page number 25.
24A.
Yeah, 20, page number 25, annexure 6 of 6. On that day, the meeting was conducted, and Your Lordship, in fact, we in the day of the meeting,
Page 25.
25, yes, Your Lordship.
What is this?
This is the order passed by on the day of the meeting. The deputy commissioner passed the order. So this is the order copy. On that day, Your Lordship, we have submitted one representation to the deputy commissioner. That is in the page number 22. Before the concerned authority, page number 22.
What is this order? Is this Page 25 is impugn order or what?
Yes, this is the impugn order.
Hmm.
Yes. So on that day, we have submitted one representation, Your Lordship, on that day only, on 8/7/2025.
Okay.
Yes,
Which
it's in page number 22. So we have submitted this representation to bring on record the order dated 25/8/2023. So in this representation, we have mentioned that the decree has already been passed in 2023 and there's no dispute. You wanted to let the authority to know that there's no dispute. Your Lordship, now I would like to read the order, the impugn order passed by the Deputy Commissioner. It's in page number 25, Your Lord.
Yes.
Yes. Your Lordship, I will read from the second paragraph, page number 25. This is the impugn order. In pursuance to notice issued, both the parties of the instant case appeared before the undersigned on 8/7/2025 at the 11 hours. After hearing the matter at length, the payment of compensation against all
8/7/2025.
Yes.
Okay. Yes.
The day of the meeting.
Yes. Yes.
Yes. After hearing the matter at length, the payment of compensation against all the properties like house, horticulture, item, etc. standing in the proposed stretch from Pampam Yarlo to Taking Lintak should be released without further delay. The payment of land compensations against the stretch from Bampam Yarlo to Taking Lintak is hereby kept at hold till the title of the land is amicable settled at the appropriate forum. Your Lordship, this is this order is arbitrary in law, Your Lordship. When the same authority releases a compensation for the structure standing on the land, but withhold the compensation compensation amount of the land itself, there is no intelligible differential, Your Lordship. This is a clear violation of Article 14, Your Lordship. The Deputy Commissioner acting purely as a dispersing authority, Your Lordship. He has no jurisdiction to sit in appeal over the final order, Your Lordship. He has effectively reopened the concluded issues, which is wholly without jurisdiction, Your Lordship. He was there. He has been acting as a purely as a dispersing authority, Your Lordship. He cannot reopen the settled final order, Your Lordship, which is a binding order. He has no jurisdiction for that, Your Lordship, which is wholly without jurisdiction. He was doing that, Your Lordship. The Deputy Commissioner, he should disperse the amount of the structure, household of that land, Your Lordship. When he is saying that is in dispute, but he dispersed that amount, but he did not disperse the amount of the land itself, Your Lordship. That is a violation of Article 14, Your Lordship. And after that, Your Lordship, on 28/7/2025, it's in page number 28. We have submitted one representation, Your Lordship, after this order. Page number 28, Your Lordship. In this representation, we pray for review and modifications of the order dated 8/7/2025, Your Lordship. But we have not received any response for this order, this representation, Your Lordship. Because of that only we are here. Now, Your Lordship, I would like to bring on record the affidavit filed by the respondent number 1 and 2, Your Lordship.
Yes.
Yes. Affidavit filed by the respondent number 1 and 2, Your Lordship. Page number 41.
Yes.
Para number 3, Your Lordship.
Mm.
Page number 41, para number 3.
Page 41?
Page 41, para number 3, Your Lordship.
No. If it is para 3, then it is 39. Affidavit filed by respondent number 3.
No, Your Lordship. Respondent number 1 and 2.
1 and 2.
Yes, the page number 41, Your Lordship. Page number 41. Filed by the respondent number 1 and 2.
No, 41 is something different.
Yes.
One and 2.
Yes, Your Lordship.
Para 3 would be page 47.
Is it 47?
Yes.
Oh, with me it's 41.
The page from 38 to 45 is affidavit filed by respondent number 3.
Okay.
And then page 46 onwards,
Yes.
affidavit filed by respondent number 1 and 2.
Oh, we have like 32 to 39 filed by the respondent number 3.
No.
No, no.
There is, I think, no, the pagination also.
There's a mistake in paging.
Mm.
आप लोग सेम है सर का कितना पेज नंबर 46 to 50. If it is 46 to 50, then 47, yes, Your Worship, 47. Because with us, it's 40 to 44.
Yes, 47.
Yeah, maybe there must be some mistake. Para number 3, Your Lordship. May I read? That with regard to the statement and allegation made in the writ petition by the petitioner, the deponent humbly states the following in nutshell, that from the available record, it has been found that on dated 25/8/2023, the then executive magistrate C. Yomi District Monigong had passed an executive order in regard to land dispute case among Hemi Hedu clan versus Ningyo clan. Based on the Kebang decision and final settlement passed by the village authority dated 26/4/2021, and in the Kebang, it was declared past that the disputed land from Pangpam Yarlo to Teking Liktak belongs to both the brothers, that is Hemi and Hedu clan. And it was also assumed and accepted that whenever the compensation for the said land shall be released equally in between both the clan brothers. Next para. That further, it is stated that the Hemi clan has accepted the 50/50 equal distribution of the compensation amount based on the Kebang decision 26/4/2021. However, the Hedu clan has not accepted the sharing of compensation amount, but they have not challenged the Kebang decision as well as the execution order dated 25/8/2023, passed by the executive magistrate Monigong. Moreover, there was no any kind of dispute at the time of land survey and acquisitions of the land done under the Deputy Commissioner C. Yomi District and the Kebang decision and executive of Kebang decision by Magistrate Mogong was never been challenged or caused before any competent authority. Earlier, on dated 8/7/2025, that is the impugn order, the Office of Deputy Commissioner Tato had issued an order that the compensation disbursement of the stage from Pampang Yarlo to Teking Lingtak be kept in whole till the title of the land is settled. But there is no record of any appeal and any order from any authority staying the disbursement, nor any title suit filed in any forum by the Hedu clan. Therefore, there seems no any ground to keep the compensation matter pending. The Accordingly, in absence of any stay, restraint order from competent court, there seems no any legal impediment for distributions of compensation amount for the stretch of Pampam Yarlow to Taking Liktak, which is a community land of Hedu Hemi Society as per the Kebang decisions and the executive order. Your Lordship, they themselves admitting it, Your Lordship, that there's no challenge, they have not been challenged any order, there's no stay, and there's no legal impediment for the disbursement. They themselves, the respondent number 1 and 2 is admission 18. Having said that such admission, Your Lordship, now they cannot contradictory their stay and deny the compensation. Their stay and the compensation. Your Lordship, our case is, it's not about the apportionment or title. There's no, this is not the case of apportionment and title, which has already been attained its finality, Your Lordship. They never challenge it. They never file any suit and any appeal in any court. Today we are here only for the implementation, non-implementation of the order, which has been passed in 2023 by the Deputy Commissioner. And now they themselves, the Deputy Commissioner, respondent number 1 and 2 themselves are admitting it, Your Lordship. They are admitting it as per the affidavit, Your Lordship. And this is an admission fact, Your Lordship. That's why today we are here. We are praying to this honorable court to cause the order, the impugn order passed in 8/7/2025, and this instruction for the release of the compensation amount, Your Lordship, between the two brothers. That is Hedu and Hemi. Yes, Your Lordship.
Yes. So according to her, the government is our party.
Yes, my lord.
So now you're left alone.
Yes, my lord. But here the issue is disputed question of fact, my lord. My lord, may please come to page 18, my lord. 18, my lord, of the
Just a minute.
issue. Yes.
Yes.
Yes, 18, my lord.
Yes.
Third paragraph, my lord. Words written in bold letters, my lord. So we came to conclusion that this disputed land from Pumbum Yorlong to Bos Sokong, my lord.
Third paragraph. Father.
Yes, in the Kebang, no, not the father.
In the Kebang.
Yes, my lord. In the Kebang. The bold letter, my lord. So we came to conclusion that this disputed land from Pumbum Yorlong to Bos Sokong, my lord, belongs to both brothers, my lord. Both, it is an admitted fact, my lord. Both the petitioner and the respondent, even me, my lord, I have not annexed the Kebang decision, my lord. This is the execution order, my lord, executive order, my lord. This executive order also has been passed without applying proper law, my lord. My lord, there is no section 412AB, my lord. The amendment is made on section 44, my lord, of the regulation.
Okay, whatever may be. But 2AB is there.
There is no 4AB, my lord. The amendment is, my lord, in regulation section 44, my lord. Section 44(2), my lord. That is the amendment, my lord.
Should have been 4.
Yes.
44. But
Yes, my lord.
1 4 missed.
One.
Roman 1 is also not there, my lord. Roman 1 is also not there.
No, 44 1.
The wrong law has been quoted, my lord.
It should be 44 2AB.
Yes, my lord. And section 145 of CRPC has been invoked. My lord, whether in execution, section 145 of CRPC can be invoked, my lord.
Your Lordship, for that, they could have challenged appeal before.
Yes, yes.
Yes, Your Lordship.
I think you have done your job.
Yes, Your Lordship. Thank you.
And also in order to mention. Yes.
Yes, my lord. My lord, my contention here is, my lord, this third paragraph, my lord. The area of land, my lord. From you Pumbum Yorlong to Bose Sokong, my lord. Now, my lord, may I please.
Paragraph?
Yes, my lord.
Oh,
Of page 18, my lord.
okay.
But this is not the Kawang decision, my lord. This is only an executive order, my lord.
No. This is only reference that in Keba decision
Yes, my lord.
settlement, it has been declared.
So we cannot primarily rely on this document, my lord. We have to see the Kawang decision, my lord.
Do
Secondly,
you have a copy of the Keba decision?
I do not have, my lord. But page 19, my lord. This is the representation by the petitioner, my lord. Now, my lord, in the bold letters, my lord, Pumbum Yorlong to Taking Lingtak, my lord. This is now separate area, my lord. This is not Bose Sokong, my lord.
Yolong to Bos Sokong.
Yorlong to, yes. In page 18, it is Bose Sokong, my lord. Bose is Bose Sokong, yes, my lord. In page 18, it is Bose. In their representation, my lord, it is Pumbum Yorlong to Taking Lingtak, my lord. This is a different area, my lord. Not the same stretch, my lord.
Opposite side?
Yes, my lord. Downwards, my lord.
Huh?
Downwards, my lord.
Downwards?
Yes, my lord. Not in the single stretch, my lord. So this is a disputed question of fact, my lord. So Deputy Commissioner was correct, my lord, to the fact that there is a disputed question, my lord. So even the notice on page 21, notice issued by the Deputy Commissioner, in the second paragraph, my lord, it also says, my lord. My lord, may come to second paragraph, last part of the second paragraph. Pumbum Yulung to Taking Lingtak, my lord. Now the executive order says, my lord, Bose Sokong, my lord. It was making a reference to the Kawang decision, which is related to Bose Sokong, Pumbum Yulung to Bose Sokong, not Lingtak, my lord. Taking Lingtak was not there, my lord. It's a separate area.
Now the compensation amount is for which area?
Taking Lingtak, my lord. My lord, I have one document, my lord. I would like to produce one. Just now I have received the instruction, my lord.
Not for Pumbum Yolong to Bos Sokong.
Yes, sir. My lord, there is a final award, my lord. This is the final award, my lord. Final award, my lord. In the second line, my lord, name of the village, Tato Pumyang Hongte Taking Lingtak, my lord. This is a stretch, my lord, where the road is being constructed, my lord. This award is regarding the Taking Lingtak, my lord. This stretch is different, my lord. Not the Bose Sokong, my lord. Now the application of Kawang decision cannot be applied here, my lord. Because of that, my lord, Deputy Commissioner has passed the order, my lord. There is a disputed question of fact, my lord. If my lord desires, I can file additional affidavit, my lord, by bringing this on record, my lord.
Which one?
This affidavit, this notification, yes, my lord. This is the final award, my lord. After passing of final award, they don't have any, my lord, grievance before this honorable court, my lord. Or this honorable court has no authority, my lord, has no jurisdiction, my lord, to entertain this writ petition, my lord. This writ petition itself is not maintainable, my lord. As per section 64, my lord, of Lara Act, my lord. Or they have a forum available, my lord.
What forum?
Reference authority, my lord. Section 64, my lord. I have raised this, my lord, maintainability of this writ petition, my lord. This writ petition is not maintainable, my lord.
Where in your affidavit you have stated that this is not the same area?
But they have not brought the Kawang decision, my lord. So why we cannot? But
Do
we
you
have
have a
said
copy of Keba decision?
So we don't have, sir. We have this order only. This is the main order.
Just a minute. Now, what do you have to say?
Yes.
Regarding this, because this decision, the executive magistrate order
Yes, sir.
for execution.
Yes, yes.
And according to you, the decision.
Yes, yes.
The lane.
Yes.
From Pumbum Yorlong.
Yes,
to
sir.
Bos Sokong.
Yes.
Could be seen from the order.
Yes, yes.
But then immediately after that, you said that representation was submitted as they were not agreeing with So these in the this representation also you have changed Pumbum Yolong to.
Sir, Your Lordship, it's come under this Pumbum Yolong to the same order passed in 2023. Your Lordship. It's come under the same area only.
No. Where do we find that it comes under same area? Anywhere mentioned that this is the both Sokong and Taking Lingtak is the same and not the different area.
It comes under the same area only, Your Lordship. Let me go through it and.
If this is same area, it's fine. But then if
Yes, it comes under the same area only, Your Lordship. Because of that only, Your Lordship, the Deputy Commissioner, respondent number 1 and 2, they have submitted their
no
affidavit, Your Lordship. If there's any dispute, they could have said that. Yes, sir, they would have said. Yes, Your Lordship. And yes, Your.
Our affidavit is with regard to the definition of occupation of area stretching from Pumbum Yolong to Taking Lingtak.
Yes, that is there. But then there you said that in between the Hedu and Hemi.
Yes.
So Hedu and Hemi, if they are in the Pumbum Yolong to Taking Lingtak, then it's the same, it appears.
Yes, this area belongs to both the clan brothers here.
Okay, area belong to both. Then it's the same.
Yes.
No, my lord, this Kabang decision is bosses of my lord. Kabang decision is relating to bosses of.
No, the government. The
Yes.
DC also say it's the same.
My lord, DC was not a party to the Kabang decision, my lord.
But DC has passed the order.
No, my lord.
The impugn order.
Yes, the DC has passed
yes,
in order.
Impugn order, it's also
Because there was a dispute, my lord.
But then you see, by this order, it is presumed that there is a Cabinet decision.
Yes.
Kabang
If
decision,
you
my
are
lord.
aggrieved by the Cabinet decision, you could have challenged.
My lord, it is not in the same stretch, my lord. That has to be identified, my lord.
No, after identification only the DC says now, by affidavit, it belongs to both the clan.
may I, Your Lordship?
Yes, please.
Annexure 6, which is the impugn order, Your Lordship, it does not mention any Kabang decision.
Which one?
The
Page 25.
impugn order, Page 25.
Page 25?
Yes.
No. See, this, because the decision of the executive magistrate was based on the Cabinet decision. Based on the Cabinet decision, the petitioner has claimed, informed, since the Hemi clan did not participate, so they made this representation also. And based on representation, DC has issued notice. And after issuance of notice, then this final decision.
In relation to my lord, the area has to be.
No,
appreciated,
so
my
that is why it's continuation. It appears. Now the government also by affidavit says that it's the same land and that the land belongs to Hedu and Hemi clan.
lord. We object to that, my lord.
Now you have
This
to,
land
you
belongs to us.
have to challenge.
Yes, my lord, because of that, my lord. We both have to challenge it, my lord, because there is a final award, my lord. Now, as per section 64, my lord, we have to approach before the reference authority, not before this honorable court. Because evidence has to be laid, my lord. Read court will not take the evidence, my lord.
No, this appears to be the executive magistrate orders.
Yes, my lord.
This is not the decision in a civil as a civil judge.
Yes.
This is an execution.
Yes, sir.
In execution of the order passed by the village authority.
But the original decision is not here, my lord. Not before us, my lord.
So see the decision mentioned
My lord.
in the execution.
Yes, my lord.
If
My
you
lord,
agree by the original decision, you have to find out and challenge it.
my lord, any issue that has been cropped up in the land acquisition, my lord.
For the purpose of this order, she don't have to produce the original decision because this has already been mentioned. She can produce, but without production also, this has already been referred. Based on that only, this has been execution petition initiated. Based on the decision of the village authority only. Clearly. Only the area what you say, that has also been clarified by the deputy commissioner, the respondent, that this land also belongs to both. If the land area belongs to both, then it's.
No, my lord, this deputy commissioner cannot pass this order, my lord. He can only pass.
Then it has to
award.
go, the deputy commissioner order has to go. Then he has, then the petitioner
My
have.
lord, petitioner, yes, my lord, there is an award, my lord. Now there is an award, standing award, my lord. They have to approach reference authority, my lord.
No,
Under section
no,
64,
we are not concerned with that.
my lord.
We are not concerned with that. We are concerned with this deputy
Right.
commissioner's order.
My lord.
If it goes, then where she approach, it's up to the petitioner for the compensation.
My lord. Yes, of course, my lord. That can be done, my lord. They can approach appropriate forum, my lord.
Because for the compensation, if it is already paid, it appears you are out.
Your Lordship, they did not pay for the land, only for the structure.
Only for the structure.
Yes, only for the structure. So same length, but only the structure. Those who made some kind of food,
Okay,
fruits
for the
and all.
land yet to pay.
Yes, yet to pay.
Okay,
Yeah.
we only will say, only will say that this, because while admitting that the order was passed in execution, the order was what do you call, the village authority has already decided, and the execution petition, in the execution petition also decided it belongs to a board. Then this, if it belongs to board, then the deputy commissioner cannot say that the land is under dispute, still under dispute. It has already been decided because you have not yet challenged.
My lord, that is with regard to another stretch, my lord. Bose Sokung Alog is another stretch, my lord.
Whatever the stage may be, but both belongs to them, this Hedu and Heavy clans. The deputy commissioner clarified.
My lord, deputy commissioner cannot pass a decree, my lord. This
Deputy commissioner also, no, not the decree. No decree was passed. Only says,
by way of this affidavit, they are saying.
deputy commissioner only says that there
is a
land
dispute,
still under dispute.
Yes, my lord.
Whereas the land is not under dispute now.
No, my lord, there is a dispute. We are contesting, my lord.
No. No, but if you are contesting, then where is the challenge?
That is in relation to Bose Sokung, we have no objection, my lord. But Taking Lingta, we have objection.
Then Taking Lingta, the deputy commissioner is a continuation of this only.
My lord.
Then in the continuation of this, when the complaint filed before the deputy commissioner passed the impugn order.
Yes, my lord.
So while assessing,
there is
while assessing, probably before payment, some assessment also is to be done, yet to be done, it appears. The lane is to be measured, who's whom, how much. So then, if it is not a Taking Lintak, automatically they goes, because whether Taking Lintak or the Bose Sokong belongs to both Hedu and Hemi only. According to them, according to the DC also. Both belongs to Hedu and Hemi only. If it is not belongs to both Hedu and Hemi, automatically this Hemi clan will go. If it belongs to Hedu and Hemi, 50% is entitled to the Hedu, 50% to the Hemi.
My lord may interfere, but my lord may not say anything because there is a forum.
We will restrict. We will say only to the extent what this court can say.
Even my lord, this is settled. My lord, after passing of award, the deputy commissioner has no power.
We will not say anything about the award.
Yes, yes.
But then, the deputy commissioner orders will have to go in view of this order passed by the executive magistrate and the settlement of
it will have impact on the
no. Then ultimately the claim when on ground when it goes, then if it doesn't belongs to the Hemi clan, the petitioner, they will not entitle. They will not be paid. But if it belongs to them,
once the money are paid, my lord, nothing will remain. Once the money are released, my lord, nothing will remain.
No, but before release, they probably have to. But we'll make some observation that ensure before release the area, not the dispute of the lane, but the area where. Okay.
And that, my lord, then my lord, this writ petition, my lord, I am saying this writ petition is not maintainable, my lord, because this regarding
if it is dispute of fact, it's not maintainable. But this is not a dispute of fact. I also thought initially that this is dispute of fact.
My lord.
But this is not a dispute. This is execution order. Order in execution of the order passed by the village authority.
So we are not in hand with the Kebang decision, my lord.
Kebang decision. See, this is execution. Execution clearly.
Execution order passed by referring to a law which does not exist, my lord.
No,
there is no section 4, my lord.
This is a mistake, of course. We should count as a typographical mistake. Section 4, instead.
There is no section 4.
44 only mention 4.
Correct.
Typographical mistake only. But then subsection is 2AB.
And then section 145 CRPC, my lord, they have invoked.
So that is considering that
Or section
likely
145
to arise.
My lord knows better than me, my lord. Section 145, my lord.
That is, see, why he has inserted it, and also in order to maintain peace,
my lord.
That inserted.
My lord.
Considering the likely to arise, then this order he has.
I may be given some time, my lord, 1 week time, so that I can file this in the affidavit form, my lord.
Which one?
This award, my lord. Final award. In the form of affidavit, 1 week time, my lord.
No point, Your Lordship, because we are not here for the.
We want to bring it on record, my lord.
They should have challenged it in it before, Your Lordship.
After a week, my lord.
This is not any use. They are doing it tactic. They are using their tactics to delay the proceedings, Your Lordship.
No, no. Because after passing of
Your
award,
Lordship,
my
that
lord,
is a different case.
In the meantime,
Yes.
Yes, my lord.
then what we can do is, since he has spread and some, this is a new development, it appears.
Yes.
So in connection with that, of course, it will not affect you.
Yes,
Yes.
of course.
But then, in the meantime, if you also can find the Kaba decision.
Yes,
Kaba
my lord,
decision
yes.
also,
Yes, Your Lordship.
That would be much better.
Because this is the Kaba decision is in favor of both the
Yes,
clans.
yes, yes, sir.
If that is there, because he is repeatedly asking for the Kaba decision,
Yes, ma'am.
if you have the copy is available with you or your client, you can also bring it.
Yes, they can also file affidavit, ma'am. Yes.
Your Lordship,
Hmm.
this the award, final award, it's in on 29 May 2025. 29 May 2025.
Mhm.
The date is written there. And Your Lordship, they have filed their rejoinder, their affidavit,
Okay.
counter
after that
affidavit.
only.
Yes, already filed their
They
affidavit.
already, I have received
Yes,
this award, my lord.
Whatever
This
it
petition
is.
was filed
Yes, Your Lordship.
Yes, sir.
September.
Yes, Your
You
Lordship.
could have.
Yes, sir.
This was all.
Today only I have received this
Yes,
After
Your
that only
Lordship.
it was filed.
Yes, Your Lordship. The
No,
Deputy Commissioner filed after this award only, Your Lordship.
I have received this award today only, my lord.
I think only. Just a minute.
It's only a matter of 1 week.
After decision, what had happened to Hemi clan, we do not know. Hedu clan, we do not know. But then it appears that there is no dispute with regards to the land that it belongs to Hedu and Hemi clan.
Yes.
Yes, Your Lordship.
So in that view of matter, I think no point keeping it pending.
Yes, Your Lordship.
But I would like to only file this affidavit one, this notification one, in the form of affidavit.
No point, Your Lordship. The order of the 29 May 2025.
My lord, on the last order, my lord, it was reflected, my lord. I have raised the objection as regard to maintainability, my lord.
But this time I have cleared that maintainability also, Your Lordship. And this affidavit, opposition affidavit
Only,
filed.
say, only
Yes.
the deputy commissioner has
Yes,
put the payment of compensation into hold only.
Yes,
yes,
sir.
yes, Your
So
Lordship.
they have already, he has already decided.
Yes.
Yes, sir. Fine.
Let it be released.
Yes, sir. Let it remain for a week, my lord. I will file.
No, Your Lordship.
Now, how it will help you?
It will help me, my lord, this, my lord, on the maintainability part.
It won't help,
That's
Your
already
Lordship.
heard.
At least, my lord,
Maintainability notes raised earlier.
after,
Yes,
after,
In the
after passing of award, my lord, the deputy commissioner has no power, my lord. No power in compensation matter. That is a settled law, my lord.
we'll make a mention about this also.
Yes, sure.
If I can bring on record, my lord, 1 week, my lord.
No, Your Lordship.
A date may be fixed, my lord.
No, Your Lordship. He is just using the tactic. Your Lordship, moreover, the date is written there, 29 May 2025. That means this award has been received by the Deputy Commissioner. After that only, Your Lordship, they have filed the counter affidavit.
After this, only the deputy commissioner also.
Yes, Your Lordship. After,
You
yes.
as well.
Yes, Your
No, my lord. Just today only I have received
Yes,
this
Your Lordship.
notification.
Okay.
During break time, my lord.
next week.
Yes.
Any
No, Your Lordship,
date?
Your
Next
Lordship,
week, any convenient date?
Yes.
no, Your Lordship.
Because he has to also submit one.
No, Your
Kabang
Lordship,
decision.
kindly, Your Lordship, because this is, if the date is like recent date, then I would have understand this, like this is a new
Further
thing.
hearing will be taken.
Yes, yes.
Yes,
Only
yes.
this.
Yes, only that.
No further hearing will be taken.
Yes, yes.
Then Your Lordship, short date,
Yes, short date only next week.
next, today is,
Today is Wednesday. Only Thursday, Friday. Tomorrow is DV day. Day after tomorrow, if it can be.
14.
day after tomorrow, Your Lordship.
14, my lord.
14.
Yes, my lord.
14, no, Your Lordship,
this
I won't be
government,
here.
my lord, they-
Your Lordship, I won't be here. Kindly do it like
No,
day after
just a minute,
tomorrow, Your
just a minute.
Lordship.
We'll fix it on 11 or 13.
11 would be,
Okay.
Yes,
yes, sir. 11, Your Lordship.
Had Miss Jonglujo, J. Jonglujo, Land Council for the petitioner. Also had Miss Sangita for the state respondent number 1 and 2, and Mr. B. Picha, Land Council appearing on behalf of the respondent number 3. Yeah?
3, yes, ma'am.
Okay. At this stage, Mr. B. Picha, Land Council for the respondent number 3, submitted inadvertently the final about notification dated 29 May 2025 could not be annexed at the time of filing his affidavit, and praised for allowing him to bring on record the said notification by way of filing additional affidavit.
Additional affidavit.
The prayer is allowed. List is as requested. List this matter again on 11.
13, my lord, 13.
11, please, 11. I've already accepted your request.
Obliged.
Highly obliged, Your Lordship.
Item number 17.
ये नोटिफिकेशन यहाँ का है तो रख दो. Oh yes, yes. It's going. Yes. Yes. Item 17.
Yes, Your Lordship. Your Lordship, I'm appearing on behalf of the senior counsel. So, in Your Honor, this matter, Your Honor, my senior counsel has instructed me to get adjournment for today's because the counsel is from outside.
Okay.
So, it may be kindly fixed on 10th of June.
10 June.
10th June, Your Lordship.
No objection.
No objection.
Okay, Mr.
In Kakum,
Land Council appearing on behalf of.
on behalf of the senior counsel, Your Honor. Your Lordship, Mr. A.K. Singh has engaged me for to.
Okay. Well, submit that Mr. A.K. Singh, Land Council, to the respondent. Oh, A.K. Singh is from here only.
But Your Honor, that conducting counsel is from outside.
Okay.
Andhra Pradesh is
Means
from.
that the conducting council who is stationed at outside the state is could not appear court today. Therefore, praise for the gentleman of the matter for the day to be listed on 10th
June, Your Lordship.
to which Miss
Vaiga Lordship.
on
behalf of M. Kato.
On behalf of Mr. M. Kato, Planet DSTI, has no objection. Prayer allowed. List this. Accordingly, list this matter on 10th June. This is for order only.
Yes, Lordship.
Yes,
Just a minute, huh?
Yes.
I thought this is for a hearing.
But they are not. Okay.
Next. Okay.
Obliged, Lordship.
Deeply obliged, Your Lordship.
Item number 18.
Yes.
My please, my lord. My lord, I'm appearing for the private respondent in this case, my lord. From 5 to 23. Respondent number 5 to 23, my lord. So we need kindly allow us some time to file affidavit of opposition, my lord.
State has filed.
No, my Lordship. Extra copies, they are going to serve us today.
Okay. Mr.
T. Tatak.
T.
Tatak.
Sorry, Tatak. Land Council for the petitioner.
I'm for the
You are appearing for the first time?
First time, my lord.
Okay.
M.
Ms.
Ratan.
Wang, Land Council for the state respondent. Some says they have not been furnished with the extra copies by the petitioner. The petitioner, the Land Council for the petitioner shall furnish extra. How much? How many copies?
2 copies.
Extra 2 copies of the writ petition. Sorry, this is writ petition only to Miss Wang Mulani Government Council within 3 days from today.
Lordship, it is a humble prayer. There's a new discovery in this case.
Okay.
And pertaining to this case, there is again a dispute in the criminal cases. So there is no status quo have been passed in this writ petition.
There is
so
no?
in the next, there is no status quo.
Okay.
There is no status quo. Interim orders have not been passed in this case. In the next hearing, it may be considered, Lordship. For
Okay.
hearing for the interim.
Okay. Mr.
M. Ratan, my lord.
M. Ratan.
M. Ratan.
Land Council put appeared on behalf of the respondent number 5 to 23 by filing Wakalatnama and prays for some time to go through the matter and to file affidavits. A response, if any. The prayer is allowed. Stop. Age. Okay. Prayed for. Comma. List this matter after 3 weeks.
After, my lord, on 17 June, my lord.
17 June.
17 June, my lord. After 4 weeks.
Okay. On the request of the Land Council for the parties, list this matter on 17 June, on which date the interim prayer of the petitioner shall be considered. Okay.
Deeply obliged, my lord.
79.
Yes.
Item number 19.
My lord, in this case, the petitioner is present. My lord, and here, just I make a small submission, my lord. This matter can be remanded back to the authority, my lord. Basic challenge, my lord, made here in this writ petition is that I'm private respondent, although I'm private respondent, but I feel that without entering into the merit, this can be remanded back, my lord, because there's an interim order. It's of no use of keeping pending interim order in force, my lord. So, my lord, the fact of the matter is that the LPC obtained by the petitioner was cancelled by the additional deputy commissioner Balijan, who is the issuing authority. Against that, my lord, against that order, my lord, later on, he approached this honorable court in earlier round of litigation, wherein this honorable court has found that there's a appellate provision under the Land Records Act. So therefore, instead of approaching this court under 226, you approach to the appellate authority and the appropriate forum. Accordingly, as per submission, he submitted the application to the Secretary Land Management pursuant to the court order, my lord, got this earlier litigation, the Secretary Land Management. Then Secretary Land Management, instead of considering the matter by himself, he endorsed the matter to the Deputy Commissioner, Papumpara District. Then Papumpara District, on endorsement, he considered a matter, and on merit he disposed of. Now, against that disposal order, petitioner come up with this writ petition, challenging that the Deputy Commissioner could not have disposed of, could not have considered because he has no jurisdiction. This should have been considered by the Secretary, being the appellate, not the Deputy Commissioner. Their contention is this. Deputy Commissioner includes the additional Deputy Commissioner. Therefore, since definition includes Deputy Commissioner, that being the position, the Deputy Commissioner could not have considered, taken up the appeal against the decision of the additional Deputy Commissioner of the Balijan. Now, in that aspect, my lord, I feel that without entering, although there's a certain issue, but I personally feel that without entering into merit, my lord, this can be remanded back to the Secretary concerned to consider that since the application itself, representation itself was addressed to the Secretary, my lord. only the provision they are harping on. Otherwise, they're relying on the land records rules only, definition part, relying on that part. Without entering into this, can be remanded back. This definition of they're relying upon the definition of section 2I, my love. 2I, Deputy Commissioner means Deputy Commissioner in charge of district in Arunachal Pradesh shall be deemed to have include the additional Deputy Commissioner. The point I've raised is that since the additional Deputy Commissioner include the additional Deputy Commissioner. So this aspect, my lord, this can be remanded back, my lord, to the secretary, my lord.
My lordship, before going further with his argument, it is like it is listed
prayer
for
only.
three.
It is their prayer only. I'm considering their prayer only, my lord. It's not a.
My lordship, it is listed in order for 2-3 times for filing affidavit in opposition. And yesterday night only we received that copy. So for that we need some time.
My lord, that's why I'm not relying on my affidavit also. My lord, my concern is, my lord, this can be.
Let us see the prayer.
My lord. My lord, their prayer 26, my lord, page 26. This is first prayer is, my lord, whereby this order, secretary has endorsed the Deputy Commissioner. The letter representation addressed to the secretary, it was endorsed by this 12 August 2024 to the Deputy Commissioner. Then, my lord, this is second, my lord, the prayer B is the which they are challenging, the decision of the Deputy Commissioner. And secretary, this is C is same, my lord.
Appeal is pending.
Yes, ma'am. The appeal has been disposed of, but their contention, since this has been decided by the Deputy Commissioner, that Deputy Commissioner order should be interfered with as he has no jurisdiction, rather that the earlier appeal, madam, which is addressed to the secretary, should be considered by the secretary himself. That's the only, madam. In that being the position, madam, I do not find much, madam, to argue in this point, madam, because entire merit will be considered by the secretary. Since there's an interim order, that is why, madam, we need, instead of keeping it pending, it can be remanded back.
Where is the impugn order? Page?
Madam, impugn order is at page, madam, 33. Page 33 to
This is
43.
Disposed by
Deputy Commissioner.
additional, okay, Deputy Commissioner.
Yes, madam. On the instrument of madam, at page 32, madam, will see this is by this order, the Secretary Land Management endorsed the representation to the Secretary, madam. Page 33.
And a person who signed the judgment and order is ADC.
Deputy Commissioner, madam.
Oh, Deputy Commissioner.
Yes, Deputy Commissioner.
Now, okay. The earlier order was disposed of by ADC.
ADC, madam.
Okay.
And against that order, my lord, will see at page 76, my lord.
Just a minute. You just give me the first order is passed by the ADC.
Yes, my lord.
Where page?
My lord, they have not annexed that order in the writ petition, my lord. But it is in the impugn order, it's reflected, my lord. My lord, at page 76, my lord. Just sequence, I'll just.
Page 76.
76. This is the appeal they have filed, my lord, before the Secretary Land Management. So it's page 76. Representation dated 21/12/2023, my lord. And this representation, my lord, although it is addressed to the Secretary, but Secretary at page 33, my lord.
Just a minute. This is okay. The order passed by the
additional Deputy Commissioner against this, my lord.
ADC also not annexed.
It is not annexed, my lord. And this appeal, my lord, representation was against the decision of the additional Deputy Commissioner cancelling his LPC, my lord. And secretary, my lord, instead of considering by this representation by himself,
I could understand.
my lord,
But if you said, okay. So where?
page 32, he endorsed to the deputy commissioner.
Just a minute. When ADC decided?
My lord, ADC decided on, my lord, 14/11/2017.
17 ADC
My lord,
cancelled
no, no.
LPC.
Cancellation order is, my lord, 17 May 2023, my lord.
By whom?
By ADC, my lord.
Okay, 17?
17/05/2023.
17/05/2000.
23. My lord, I have that copy.
Okay, you have a list of
Yes.
that?
Sir, my lord, this is a loose sheet, my lord. They are not annexed in the writ petition, my lord.
Or why? You should have annexed.
My lord, this is a writ petition. They have not annexed, my lord.
Should have.
That's only impugn order is mentioned, my lord.
No. In any case, all those relevant orders, notification would
My
ask
lord,
by
that
the
is,
court only.
that is,
for understanding.
I do agree, my lord. That should have been done by the petitioner, my lord. But because of this, my lord, the matters being delayed, my lord. That's why.
Sometimes it's very difficult.
Yes, my lord.
Because of non-availability of the
Record,
order,
my lord. Document.
required document, the court also avoid
My lord,
their
my lord,
cases.
my lord, I do.
Because we need time to search also.
Yes, my lord.
It's very difficult.
But they have not annexed
Should
it,
make it very easy.
my lord.
All the available documents.
Yes.
Mm.
They have
Let the
not
judge decide. Okay, 17/5/2023, cancel.
Yes, my lord.
LPC of petitioner.
Yes. My lord,
So thereafter?
Thereafter, my lord, this page 32, my lord, this representation, my lord, it was endorsed
Representation was submitted by?
by the petitioner
Okay. We date
at page 76, my lord.
page 76.
21.
32, you said 32?
32 is this on receipt of this representation. Page 32, my lord, the secretary.
Okay, just
Secretary has endorsed it.
the page 72, 76 is
Yes.
the representation.
Yes. And that representation, my lord, that was
Representation dated?
dated 21/12/2023. And
And
then, my lord, by page 32, my lord, it has been endorsed, secretary has endorsed the matter to the deputy commissioner.
DC which district?
Deputy Papumpare, my lord.
Okay. Itanagar.
Yes, my lord. Papumpare, UPia, my lord.
UPia.
Yes.
Then?
Then based on this, my lord, endorsement, my lord, at page 33, the impugn order. After hearing details, my lord.
This is on date?
That 7th October 2007, 10/2024. Passed by Deputy Commissioner, Papumpare District.
Okay. Then
the challenge made here in this, they have challenged this impugn order at page 33, saying that the deputy commissioner could not have decided this case because, as per definition under land records rules, the deputy commissioner definition of deputy commissioner includes the additional deputy commissioner. Only at that technical point. So, therefore, the order should have been decided. The representation annexed at page 76 should have been decided by the secretary himself instead of endorsing to the deputy commissioner. That is the only. In this aspect, my lord, my humble submission, my lord, without entering into the merit, my lord, this can be remanded back. My lord, in the merit, my lord, the private respondent is a semi-orphan, my lord. She's orphan, my lord, semi-orphan. And the fact of the matter is, it is quite shocking, but since it can be decided by the appellate authority, my lord, that's why, my lord. Plot of land belongs to the semi-orphan, my lord, the father, my lord.
They are brothers and sisters. The petition and respondent number 5, they are brothers and sisters. That's why it is a land dispute.
Not a brother and sister. After demise of father who has been the petitioner, who's the uncle, taking care of property, he assumed himself any control over and obtained the fraudulent LPC. This is the old fact, but this can be considered by the appellate authority, but without entering into matter, my lord. And under, my lord, under this...
Lordship, because for whatever the opposite counsel has said, I think for that I need any reply. And
My lord,
for
reply,
that,
I'm not...
the conducting counsel.
Okay.
I'm just...
Because
I've understood. So
Yes.
what we'll do is
we can fix a date.
No, without entering into merit, my lord.
what we'll do is we'll fix it on Monday. You just go through this,
My lord.
and then this is the submission. What he is submitting is on your behalf also.
Yes, yes, my lord.
So that is why you go through the affidavit and then try to understand. And then if there is any objection, we'll go for hearing. If there is no objection, we'll dispose of on Monday. Okay?
And if it is disposed of on, my lord, without entering merit, I'm not relying my affidavit also, my lord.
Yeah, that is why.
I'm not relying my affidavit.
This is on technical ground, purely on technical ground, because DC and ADCs are same. DC has no capacity, no authority to dispose of. Okay,
I'm not relying on my affidavit.
Okay, on the prayer of both the Lanai Council for the party, list this matter again on Monday.
My lord.
Okay, Monday is 11.
11.
My lord.
Okay. Will not force.
My lord.
Much.
Deeply.
Item number 23.
May I, Your Lordship?
Yes.
Your Lordship, in this item, Your Lordship, we have taken step upon private respondent.
Hmm.
And then the notice is also completed, I guess. There is an office noting stating that that he is going to give attendance for the case. There is some personal note.
What it says? He has received a notice.
He has received.
Mhm.
However, none of the council have been appointed yet.
Okay. So he only says so. The probably you need to obtain instruction.
Here in this matter, Your Lordship, our affidavit is almost ready.
Okay. And in respondent number 3, are you also representing?
No,
respondent
only
number 3?
1 and 2, Your Lordship.
1 and 2. 3 is represented by the standing council.
No, there will be a private council.
It's a private
party.
He's a
He's a
DFO.
He's a private respondent,
So
so
private respondent, but he is just, okay,
but he will appoint as a private counsel.
private counselor.
Private counsel.
This is a transfer method.
Yes, Your Honor.
Okay,
Private counsel.
then in that case, okay. You have affidavit almost ready.
Yes, Your Lordship is under typing, Your Lordship. It's
Okay.
ready.
Ms. Pango, Learned Counsel, Learned Government Advocate appearing on behalf of the respondent number 1 and 2, praised for further 2-week time to file affidavit. Submits that the affidavit is almost ready and will be filing, and she will be filing very soon, and praised for further 2 weeks. The prayer not being objected to by the Learned Counsel for the petitioner is allowed. Learned Counsel for the petitioner, Mr. Sering, Jambi Sering, is allowed. And so far as the respondent number 3 is concerned, it appears from the communication dated 27/1/2026. It appears that 26 written by the respondent number 3, it appears that he has received the notice. However, no one appears on behalf of the respondent number 3. He has received the notice. In view of the above, the notice upon the respondent number 3 is treated as complete. However, no one appears on behalf of the respondent number 3. Staff para as requested, list this matter after 2 weeks.
Your Lordship, there's an interim that may be continue.
The interim order passed earlier shall continue till the next year of listing.
Highly obliged.
So this man probably doesn't understand whether he need to engage or not. Probably some communication from the government side. So it appears that you have received the notice.
Yes.
It appears that if you are aggrieved or if you want, you have to contest by filing affidavit.
Yes.
You have to inform.
Yes.
Okay.
Okay.
Just inform, because he only says that whatever court passes order, he will be obeying the court's
Yes.
order. Okay.
Obliged.
Yes, obliged, Your Lordship.
Item number 25.
Your Lordship, may I? Your Lordship, I'm for respondent number 4 to 10. And this morning only I have received extra copy. So I need some time to file affidavit in opposition.
Hard, miss?
Your Lordship, may I? In the last order, I was directed to take step upon respondent number 3.
Okay.
However, due to
Not taken.
yes.
Okay,
then
Miss
M. Mele.
M.
Mele.
Learned Counsel for the petitioner submits that inadvertently she could not take steps upon the respondent number 3. Therefore, with the 3 till that, therefore pray for further 1 week time to take steps upon the respondent number 3. So the prayer allowed steps upon the respondent number 3 by step for notice. Steps for service of notice upon the respondent number 3 by a speed post with AD, as well as by usual process within a week from today. Staff. Miss
A. Rai. A. Rai.
Okay, A. Rai, Learned Counsel. Have you, Mr. Wangmo, you have you filed?
They have not served as extra copies.
Okay, Miss Wangmo, Learned Government Advocate for respondent number 1 and 2, and Miss A. Rai, Learned Counsel appearing on behalf of respondent number 4 to 10, submits that they have not yet been furnished with the extra copy by the petitioner. Stop. The petitioner shall furnish extra copy of the petition to the counsel appearing on behalf of the respondent within 3 days from today. Okay.
Yes.
Extra copy. How much?
I have received this morning.
Oh, this morning?
Yes, yeah.
You have not. Okay, then this will be for one more only. Okay, Miss Rai, submit that she has submit that she has received a copy of the writ petition this morning only, for which she needs some time to go through and to file affidavit. Huh? Okay. In view of the above, let this matter be listed after 3 weeks. Okay.
Unlisted item number 30.
Okay.
May I please, your lordship?
Yes.
By filing this writ petition, I am praying before your lordship to stay the impugn communication order. My lord, may kindly see the page 36. This is
just a minute. Huh?
Yes.
Yes.
Well, page 36 and 37. In pursuant to this communication order, the secretary directed
Page 27.
Page 27, yes. Page 37, sorry. Page 36 and 37.
What is this?
This is the communication order by the secretary to the Deputy Commissioner, Capital Complex, whereby the DC is directed to take action against me. It's for evicting me from my residential land and building. So I'm apprehending that in pursuance to this letter, the Deputy Commissioner want me to evict from my only residential building. Wherefore, I have approached before this Honorable Court to stay this impugned communication order.
Why it should be stayed?
The matter has been already heard by the Deputy Commissioner. After at length hearing in presence of the Government Advocate, the Deputy Commissioner communicated the matter to the Secretary Assembly stating that I am entitled to be rehabilitated. I am ready to relinquish my land and building, but this is the only residential building at the capital complex which I have purchased by purchasing all the landed property at village. So if I am evicted tomorrow or day after, I will be nowhere to go and nowhere to stay. But in pursuant to this order of the secretary, the DC want me to evict from my residential land. But I am living here for last 17 years,
So
more than
what, is
17
it allotted order, allotted land?
No, Your
No,
Lordship,
no,
it's
no,
not
not
allotted
allotted,
land, Your
because-
Lordship.
Oh, then you should.
Unauthorizedly constructed, Your
Then
Lordship.
it becomes difficult.
Because I was purchased this plot of land from other person.
Okay, the other person must be having allotment then.
Because many persons were there. Everybody is by constructing house, they are living there. So also I also, but they are not someone. Not
It's a government land.
Yes, Your Lordship, government land, Your Lordship.
So unless there is allotment, if unless the authority allow you to construct, and even for the construction of building also you need permission. Even if you have a allotment order also, LPC also, but then for construction of building, probably
yes,
the permission is required.
Building bylaw was the legislation of building in the municipal area was adopted and enacted in the 2010, my lord. So
Your building was
I constructed the building prior to that, 2009, 2008. But at the time, there was no objection, no interference, thinking that everybody is constructing the building, everybody is living here. So I also constructed for my living house. Now,
Then now everybody who has illegal constructed building illegally had been, I think.
But other families are not
evicted, and you
notified.
also evicted in the same way.
Yes. Nobody is notified by the respondent government. So I have a representation before the Chief Minister, Honorable Chief Minister, that I am a poor person. So in the event of evicting me,
Not the authority.
Yes, Your Lordship.
I may
You
be
should have approached
rehabilitated.
the right authority,
Yes.
the appropriate authority. No, it was since 2024.
My lord, may I kindly see page 32, my lord. This is an order of Deputy Commissioner dated 24/3/2025.
Page 30?
Page 32, my lord. It's a order, paragraph 2, page 32. That the respondent is a law-abiding citizen, and that is, I am respondent, my lord, because in the court,
This is your submission only.
Yes, yes.
You
that-
submitted you are law abiding citizen.
Yes, so that I am requesting them that,
And you said that you are ready to vacate.
yes, but I have nowhere to go, nowhere to stay. That's why some relief is required. So in the interest of justice, I may be rehabilitated. At least at this moment, I am in Jangsar now. So I need little relief for survival because with a large family, I am there in the present place of residence. That's why, and accordingly, my representation was also considered by Deputy Commissioner, but he is not proper authority that he forwarded
What
the
happened? You
order.
submitted for application before Chief Minister for rehabilitation, whether it was considered.
It is unattended till that, my lord.
So what to do?
Till that unattended, my lord.
Hmm? So it seems you have no case. Hmm? Which one is the last order? What is your prayer? Let us see.
Yes, my prayer. Page 23, my lord.
So rehabilitation only.
Yes. Because I am now helpless, nowhere to go and nowhere to stay. So relief and rehabilitation is quite necessary. Otherwise, I will have to go under the sun. At least some remedy may be considered, my lord, at this moment.
This prayer you can make before the government only, the authority only.
Yes.
What remedy the court can give? What relief the court can give? Unless you establish your right. So, Mr. Pang, what can we do?
Your Lordship, compensation claim has not been accepted, Your Lordship. And it's a government land. Our state said that necessary action against petitioner as per some Arunachal Pradesh premises eviction of unauthorized occupant take 2003, Your Lordship. In this notice my issue, Your Lordship.
Notice.
Yes. Or Your Lordship.
You want to file affidavit saying that?
A proper affidavit,
Yes.
Your Lordship.
Okay.
My lord,
Okay, hard, Mr.
But short
let
time
them
will be
file
given, Your
affidavit, my lord.
Okay, hard, Mr.
No stay must be given. Your Lordship.
Dekka, Land Council for the petitioner. Also had Ms. Pango, Land Government Advocate for the state respondent number 1 to 6.
All respondent.
To all the respondent number 1 to 6. By filing this petition under Article 226 of the Constitution of India, the petitioner prays for prays for protection and rehabilitation in the event of his eviction. from his lane. Stop resident located at Chimpu near MLA colony. And to provide adequate praise for compensation, rehabilitation and compensation, adequate compensation in the event of rehabilitation in the event of his eviction and compensation in the event of adequate compensation in the event of acquisition of his land. And RCC building. Land and his RCC building. High-rise RCC building. Staff, issue notice. Because you are not challenging the eviction order also.
No, you're not.
Eviction order from Deputy Commissioner yet too. But in person of this communication letter from Secretary only, DC may at any time evicted me. So I'm apprehending the eviction.
Since Ms. Pango. Eviction order not yet issued.
By Deputy Commissioner.
So cause notice has been issued, Your Lordship,
Okay.
on 10 July 2024.
The so-called notice was already disposed of by the Deputy Commissioner.
Yes,
This is the reflection of the order dated 24/3/2025. So I have already submitted my written statement that I am ready to relinquish the property, but at the moment I have nowhere to go. So I may be given a little bit relief. And accordingly, the Deputy Commissioner passed this order. But again, the Secretary said that.
Okay, since Ms. Pango appears and accepted notice on behalf of all the respondent, state respondent authority, state respondent, no formal notice need be issued. Staff.
My lord, till the returnable date, I may be protected. Otherwise, tomorrow or day after, I may be evicted. Till the returnable date only.
What is this order? 2/3/26 order? What
Where
is
is this
order?
order?
2/3/26?
2/3/26.
36.
2/3/26.
Oh, yes.
Deputy Commissioner.
This is Deputy Commissioner's order. 34/3.
Where is so-called notice? Okay. July 24. No?
Yes, my lord.
Ms. Pangu wanted to file affidavit, huh? No, it's fine, huh? No, yours is not clear. Because no eviction order has been passed. The so-called notice is way back on in the 2024.
According to so court's notice, I have already appeared before the learned Deputy Commissioner, and order also passed on 24/3/2025. The Deputy Commissioner suggested the government to pay lump sum compensation to me in order to survive for my family.
The government denied your lordship.
Okay, now, before issue notice, it is submitted that as the compensation claimed by the petitioner has not been accepted, petitioner has not been accepted. Stating that it is an illegal construction. Of building by encroacher. Therefore, he apprehend. No, apprehension, that will be too early. No, Mr. Rekha.
Madam.
So let them file affidavit.
Yes, madam.
Pango Samit said she may be allowed to file affidavit. Huh? Okay, prayer allowed. This is matter after 3 weeks.
Yes.
Okay.
Matter is over. Right.
Oh. No, there should be a clear impugn order.
Yes.
You impugn, you make out your case.
My lord.
Make a prayer. So without making out your case, just lump sum compensation and then protection. You have filed application before the chief minister. It is pending.
Pending.
And you are for rehabilitation. It's not a proper place.
Yes.
Huh? Not challenging, not making out your case. It will be difficult. Okay. Let them file.
Yes.
Let them say.
Yes.
Okay.
Okay. Oblige, your lordship.
Oblige.